Foundation. We are very happy to be hosting you today. It's my honor to welcome you all. The Connecticut Bar Foundation, as many of you know, has a mission of serving access to justice in the state of Connecticut. In furtherance of that mission, we do a number of things. We are the primary funder of civil legal services in the state. We also act as a facilitator and convener of members of the legal services community, as well as the bar at large, in conversations about the justice system and all of our work to make sure that that system is working in service of all of us, including the most vulnerable. So we really want to thank you for being with us today for this very important conversation. I want to thank the staff of the Bar Foundation, Stacy and Elena, who are around today. Please thank them. Every time you see them, they've been working tirelessly to pull this off in this beautiful space. And I also want to thank the planning committee for today, chaired very ably by Ernie Maddie. We are so grateful for all of the work that you did tirelessly to put this event together. Unfortunately, I have to teach at 9:30, and I have not yet been put out of work by artificial intelligence, so I'm going to have to run. But again, we really appreciate you all being here and know that you're going to get a lot out of the day. And with that, I'll turn it over to Ernie.
Good morning, everyone. Good morning. Welcome to the 5th Annual Honorable Mark R. Kravitz Symposium. This is our symposium on artificial intelligence and the law. I'm honored to welcome you all here today and our distinguished panelists. Since our efforts are to maximize the time that they spend with you, you can check their bios if you haven't already by just scanning the QR code. Really highly qualified people, and we're delighted to have them. AI is one of the most transformative technologies of our time. It's already having a profound impact on our lives, and its influence is only going to grow in the years to come. AI is also having a major impact on the law. AI-powered systems are being used to automate legal tasks, make legal predictions, and even provide legal advice. This is raising a number of new challenges and opportunities for the legal profession. This symposium will explore the intersection of AI and the law in depth. We will hear from leading experts on a variety of topics. I would encourage you to listen carefully, because there is a lot that you will be able to take back with you. I am confident that this symposium will provide valuable insights into the future of AI, and I'm grateful to the Connecticut Bar Foundation and my committee for all the hard work they've done. A number of committee members are here. The moderators are committee members. The title of this program was something we vetted. Tim Sharon came up with it. We all agreed that it was perfect. Justice Katz, who was a member of our committee and who is not here today, told me when I pleaded and begged with her to be on the committee, she wouldn't be able to be here. She was invaluable to us. So we're very fortunate to have had members of this committee who've done a terrific job. Before we begin, I would like to take a moment to let you know that the symposium is to honor Judge Mark Kravitz. Judge Kravitz and I went to law school together. He died in 2012, very young age. He was a distinguished lawyer and a profoundly impactful jurist. He thought that litigation was the basic foundation of the rule of law. He wrote a tremendous law school article, law review article on the Vanishing Trial, and so we honor him by having this program and having its focus on litigation. Judge Kravitz, who was a leader in terms of the use of technology in the courtroom, would have been fascinated by this program. And we are sure that we do honor by him by not only having these symposia, but by having such an esteemed quality of panels. So, how did you like my opening remarks? Pretty good? No, seriously. You know why? Because yesterday I probably spent 2 hours thinking about what I was going to say in basically 3 minutes. And then last night, as always, I thought about it in my head as I'm sleeping. I wake up and I said, okay, maybe I should change that, I should change this. So this morning, I decided to contact about 6 o'clock Mark Dubois and say, hey Mark, what would ChatGPT do if we asked them the following? That was ChatGPT. And it was done, as according to Mark, because I would have never been able to do it myself, but according to Mark, these remarks took him 2 minutes to do a prompt and 1 minute for Bard to prepare and deliver. A total of 3 minutes that I worked on 2 hours yesterday, fretted about it. I mean, it's only 3 minutes, and then on top of that, lost a lot of sleep thinking about it. So this is the significance of AI, and why I'd like to take credit. And by the way, there will be people taking credit for AI prompted remarks. I can't. It was Mark Dubois through Bart. So thank you and enjoy the program.
Good morning, everyone. My name is Allison Weir. I'm the Executive Director of Connecticut Veterans Legal Center. But really, mostly what I'm here today is the Vanna White for the first panel. Our first panel is, which figure we level set and give everyone a sort of basic understanding of what AI is. So we're looking at AI from 20,000 foot level. We've got 2 fantastic speakers. Wendell Wallach is the Carnegie Your Hero fellow founder and co-director of AI and Equity Initiative at Carnegie Council for Ethics and International Affairs. And then we'll also hear from Professor William Eskridge, the Alexander Bickett Professor of Public Law at Yale Law School. Just as sort of doing the Vanna White thing, there will probably be a lot of questions. So if you can send the questions to my cell phone, and that's on the back, panel 1, 571-212-5011. Vanna Whiting. And if you want to get more information about the panelists, again, you can QR code, use a QR code to get more details. So without further ado, if Professor Wallach could get up to the...
So wonderful to be with you here today. This is fake news. I'm not an attorney. If it was ChatGPT that had written this out, we would all say it was hallucinating. But in any case, hallucinating is sort of a friendly word for what ChatGPT sometimes does. So we're going to go through the basics about artificial intelligence and GPT and AI ethics. Next slide. If you were just to listen to the tech optimists, you would think that we are on a highway to heaven on earth, and the self-driving buses are speeding up at an exponential rate. Next. On the other hand, if you just listen to the tech pessimists, we're clearly going straight to hell in a handbasket. Next. But most of us see technology as a source of both promise and productivity, and yet there is a degree of disquiet about certain areas of research and disquiet about the overall trajectory of scientific discovery and technological innovation. Self-driving cars give us an apt metaphor for this. Technology is moving into the driver's seat as a primary determinant of humanity's future. Next. There's even the rather melodramatic possibility that we're inventing the human, or we've at least begun inventing the human species as we know it out of existence. Next. I'd like to start with this really 100,000-foot overview, because I think what we often lose in this as we focus on one technology or another is that there are vast areas of innovation in motion, many of them very profound, and in interaction with climate change, they are probably going to be the primary determinants of what happens over the next 100 years or so. If you're more interested in that aspect of it, A Dangerous Master, my latest book, is an introduction to the ethics and governance of emerging technologies, an introduction to emerging technologies, a little bit of science, a little bit of history, and so forth. Next. So what has precipitated this gathering is this generative AI moment, the the onset of the public use of generative AI. It has been less than 11 months since the public version, ChatGPT, was introduced. Its adoption rate was faster than any technology we have ever witnessed. Within 2 months, there have been 100 million uses of ChatGPT. How many of you here have used it? Can you please raise your hands? So that's pretty good. That's probably about 50%. The estimate is that roughly 12% of the adult population in the United States has now used ChatGPT. And, I don't know, I won't put it in this one. Who has heard of Stephen Schwartz? Interesting that only a few of you. Stephen Schwartz had to submit.
Oh, yes. What a goof.
So Stephen Schwartz was submitting a brief to the federal district court, and to write up his brief, he asked ChatGPT to do it. The brief included no less than 6 false citations, 6 false opinions of cases that generally did not exist and have never existed. So that's where we are. You'll hear a little bit about Stephen Schwartz, but this is the beginning of your introduction to not be Stephen Schwartz. That if you're going to use these technologies, that you understand them well enough that you can use them properly. So next slide, please. A brief definition of artificial intelligence. There's a lot of argument over how artificial intelligence should be best described. Excuse me for a minute. I like this, and it's a simulation of human intelligence processes, human cognition by a machine. Now notice that I didn't say emulation of human intelligence processes, because a lot of the ways that machines will match our acumen, they will do in ways very different than we would. Next slide, please.
Oh, sorry.
So generative AI, which ChatGPT belongs. Generative AI is a class of AI technologies that produce output such as text, images, data sets, or other media in response to user prompts. ChatGPT is one form of generative AI, but it's not the only one. This is going to be good. There are programs such as DALL-E. This is the problem we're going to have. Okay. Can we go back a slide, though? Sure. There are programs such as DALL-E that work with images, and there are other forms of generative AI that can work with sound, with video, with even computer programs. DALL-E is an image creator. The image on the left was created by DALL-E 1. Somebody just said, create an impressionistic fox for me. The image on the right was created by DALL-E 2, a later version of DALL-E. And this image right here of the 15 chairs, the prompt was, create an avocado chair. Next, please. So, unfortunately, this is where we had. Unfortunately, this is where we had trouble with our technology, and this is an output that I got from ChatGPT, just to show you a little bit of what it can do. So I asked it to tell me who Ada Lovelace was. And I'll tell you a little bit about who she was also. And within about 3, 4, 5 seconds, it came back with this 4-paragraph essay for me that was very well organized and hit the high points of what most people would want to know about Ada Lovelace. So I'm just going to read you the first paragraph. Ada Lovelace, born Augusta Ada Byron on December 10, 1815, was an English mathematician and writer, chiefly known for her work on Charles Babbage's proposed mechanical general-purpose computer, the analytical engine. She is often regarded as the world's first computer programmer. Lovelace was the daughter of the famous poet Lord Byron, but her parents separated shortly after her birth. I won't go on, but it continues in that fashion very good. But just to give you a sense of, next slide please, just to give you a sense of the breadth of ways in which ChatGPT might be used, I also asked it to write a song about the Ukrainian-Russian war in the style of Bob Dylan. And this is only half of what it wrote, but I will read to you just a couple stanzas, since we have limited time. In the heart of Europe, where the rivers flow, a tale of struggle in the winds that blow, Ukraine the battleground, where the brave hearts stand against the shadows, the Russian hand. So you can get a little sense of, the Bob Dylan style. It has choruses, it has a break in the structure of a Bob Dylan song, and then we'll do the third verse here for you. Bobbing heads in Washington whisper in the halls, diplomatic dances where the mighty empire falls. But in the quiet villages where the mothers weep, the price of freedom is a secret they keep. So Bob himself would have created a much better song. But you can all get the sense of what we're dealing with here. And that's just to give you a taste of what the output from these programs can be. Next slide, please. So I mentioned Ada and Charles. Charles came up with a concept for the first computer system that he called the analytical engine. Ada Lovelace read about it in a scholarly article, and she started thinking of ways to program to get that analytical engine to do an array of different kinds of problems. So that's what she is known for. That was really the beginning of computing. But computing and actually building machines did not take off until World War II. I just mentioned Alan Turing here, clearly one of the fathers of artificial intelligence and the fathers of computing more generally. He had already become famous for an academic piece on computing numbers in 1936, and he was drafted for the Ultra project that was working on breaking the Nazi Enigma code. And they were working out of Bletchley Park. How many of you have seen The Imitation Game, the movie The Imitation Game? So that's pretty much that story, with Turing being Cumberbatch playing Turing and the central character. At the same time, the US government was building the first programmable computer called ENIAC. And ENIAC wasn't really finished until the end of 1945-46, so it didn't play much role in the war at all. It was the first multi-purpose programmable computer, cost $500,000, which would be roughly $7 million in today's dollars, and had a tiny fraction of the power that these little suckers we all keep in our pockets today. By the beginning of the 1950s, IBM had produced the first commercial computer, the 701, and it was renting it for $15,000 a month. It ran on a vast number of vacuum tubes, each representing an on and off switch, and they blew out all the time. The computer would often have to be staffed with 15 technicians to keep changing the vacuum tubes. But by the end of the 50s, IBM was producing its first computers that were based on transistors as opposed to vacuum tubes. So next slide, please. After the war, in 1950, Alan Turing wrote an article called Computing Machinery and Intelligence, in which he talks about the imitation game and many other things that he associated with. This is truly a golden oldie of articles. Been read millions and millions of times. Should really be given a platinum record or something comparable. And in it he opens with the memorable line, "Can machines think?" And since he decides in the article that there's no good definition for intelligence, he proposes what's known as the imitation game. Really, that if the computer can outsmart a human evaluator as to whether its outputs are from a human as opposed to from this machine, then for all practical purposes, it can think. In 1956, computer scientists who'd been thinking about this decided, well, let's have a little summer conference. And John McCarthy at Dartmouth sent out an invitation where he invited a number of other figures, all of whom are more or less the fathers, there were no women in this group, the fathers of AI, to come to Dartmouth and to work on this problem. In his invitation, he called the problem artificial intelligence. An unfortunate term, but unfortunately we've had to live with it ever since. And at that meeting was Claude Shannon, the founder of information theory, Herb Simon, who won a Nobel Prize in economics, Marvin Minsky, I could go on and on about the attendees. They were unbelievably optimistic. They thought that within 10 years, they would have a computer that would beat a grandmaster at chess, and within 10 years, they would have a computer that, ooh, wow, could engage in natural language. Okay, I'm going to have to rush a bit here. It was not until 1997 that we actually had computers that could beat Garry Kasparov. And you can say with ChatGPT for the first time, we're probably getting computers we can kind of converse with. Next. So, the history of artificial intelligence had winters and summers, meaning there were periods that was very fallow, and then something would happen, and there'd be great enthusiasm, and then that wouldn't peter out, and then there would be another winter. One of these summers was produced by the advent of a proposed strategy called neural networks. Neural networks, rather than functioning around one central processing unit, had a chip to represent each of different functions. So they were sort of engaged in simulating what goes on in the human brain, where you have, I think that's 100 billion brain cells. I keep getting confused on that number. But again, that went fallow for a long period of time until next slide. Oh yeah, and they were failing at really basic tasks, like getting a computer to be able to identify the objects in a photograph, perception. These are other things computers couldn't do, and most of them still can't. Common sense reasoning, planning, analogies, and language. Language now is starting to change. We're starting to get a handle on language. So next slide, please. In 2012, Geoffrey Hinton, who had stuck, he was one of the few scientists who stuck with neural networks, he came up with a new strategy known as deep learning, through which actually he could get computers to identify the various objects in a photograph. And some of you may have seen Hinton, by the way. He was on 60 Minutes with an interview this week. They've actually played that interview a few times. And these are some of the other colleagues that helped in the deep learning. But deep learning created this major breakthrough in artificial intelligence. Not learning like your kids would do, or not even like my kittens, which I got last week, who are fantastic in learning, but a very constrained kind of learning, and yet it was very useful in certain respects. Next slide, please. One company, DeepMind, in the UK, had it play 57 different Atari games, and it learns how to play those games quite remarkably. If I had time, I would have shown you a demonstration of it playing Breakout. You would have been blown away. Go back to that slide for a minute. But what it did do, what they were able to do is create a computer that could beat the grandmasters of Go, a game considered more difficult than chess. For all practical purposes, AlphaGo is the world champion at Go. It was succeeded by AlphaZero, which was even better. But more interestingly, they created a program that could solve the protein folding problem, which is has been a major issue in biochemistry. And it solved the structure for, I think, 30,000 different proteins. But next slide. Now, large language models are what we are dealing with when we're dealing with ChatGPT. The first of the GPTs released by OpenAI was released in 2020. It had 175 billion parameters and 570 gigabytes of text. And there are other competitors to it, GPT-4, Claude, Palm, and Llama. But we are moving in the direction of having multimodal programs, meaning they will work with text, they will work with audio, they will work with video, they will work with computer programs. They will be able to interchange and go back and forth between those. Next slide, please. Okay, here's where I was going to start, AI ethics and governance. Let's just go very quickly to the next slide. The big issues are the benefits and risks and undesired societal impacts, and will the benefits far outweigh the risks? And can we manage the risks and undesired societal impacts? Deep learning made this a major concern, and about 200 different forms of principles were created, the most important of which were from UNESCO and the OECD. The past few years have been to try and operationalize those principles and turn them into standards. And we are just beginning to think about how we go from standards to policies and regulations, and which regulations we can engage in, and international governance, which is where I have been most involved recently. Next slide, please. These are the 13 big issues in the use of AI. Superintelligence and existential risks, lethal autonomous weapons, behavior and aptitude manipulation, surveillance, adversarial AI, disinformation, misinformation, bias and fairness, lack of transparency, accountability, privacy and property rights, exacerbation of inequalities, and technological unemployment. So next slide. So I think I'm going to stop there, though I did want to do a kind of philosophical ending for you of where we are in all this. But I think this at least gets you up to knowing what some of the issues are. What I was going to do here was show you something about the brilliance of ChatGPT in talking about profound things such as how it will affect human dignity. And it will say profound words, but it has absolutely no meaning, no deep understanding of what lies behind those words. Let's do this quickly. Next slide. Here's Albert. Any fool can know, but the point is to understand. And there's no understanding in these systems, in spite of what Jeff Hinton tried to say on 60 Minutes this week. This is from Einstein in 1940. And now the last slide. We have been using AI and robotics as a mirror through which to think deeply about the ways in which we are similar and the ways in which we may truly differ from the artificial entities we are creating. Clearly, one of the differences are humans have emotions, machines do not. But the real argument has been around these three different words, each of which is not as specific as we might like it to be. Intelligence, consciousness, and understanding. And for the rest of your life, there is going to be debate over which attributes associated with these words are computationally tractable. Thank you very much.
All right, I'd like to introduce Professor Bill Eskridge now.
Yes, thank you very much, Allison. Can everybody hear me?
Yes.
And see the PowerPoint slide?
Yes, we're good.
Excellent. Well, I appreciate the opportunity to be here, albeit remotely, and I apologize for not being there in person. I want to pick up, I guess, where Wendell left off, and that is with the implications of AI, particularly the GPT and other deep learning mechanisms for the practice of law. One simple way, I guess, of understanding the transition that Wendell gave you is to contrast something like TurboTax and other more primitive computer programs that rely on conditional logic. You can use conditional logic programs to play tic-tac-toe in a way that you'll never lose, but not to play chess. And so the breakthroughs that Wendell described really enable this more complicated action by computers. And the little diagram that you see to the left gives you a very simplified, multiply that by thousands, if not millions. Information is inputted into these neural networks verbally, but the neural networks convert the verbal into numbers. And then the numbers are processed through hundreds, maybe thousands of these blue dots, these neural networks, that produce then word by word. It's basically a word prediction mechanism. That is the text that you see when you ask a question to GPT-4. So GPT, as Wendell suggests, can do an awful lot, and it's improving almost every day. What it probably cannot do at this point is that it cannot do complex legal reasoning the way that a lawyer can. It can draft legal memoranda. You've seen that with hallucinations and all the various problems. But it's not very good at this point, at least not as good as lawyers, at basic legal reasoning, including reasoning by analogy and distinguishing cases. It can talk about cases, but not as subtly. I don't think it's very good at analyzing statutory plans and structures. It can give you lots of different bits of relevant evidence, like word meaning, but it's not as good at evaluating each bit of evidence in light of the other evidence, like statutory purpose, precedents, the whole act. It's not so great at applying legal principle to facts and equity, adjusting for institutional considerations, or making normative judgments. Now, all of those assertions, I say with not a great deal of confidence, because every year deep learning is improving, and it will continue to improve. And indeed, at Yale, we're working on the next generation. One interesting fact, by the way, is that case text, which has developed co-counsel, more legally sophisticated than the ChatGPT products, has just been acquired by Thomson Reuters, which gives you Westlaw. And so that might actually produce more transformation, maybe even more quickly. But even now, AI, deep learning, ChatGPT-4 et al. Have already produced a lot of facilitations for lawyers that use it, which is still, I guess, a minority. So, for example, AI can transform your websites. A lot of law firms, probably most law firms, have websites now, but AI can create more deeply interactive websites with clients or even potential clients. AI can also maybe help facilitate large-scale litigation, including class actions. A lot of routine tasks are already mechanized, either using more primitive computer models, like the TurboTax model, or using the more complicated ones like AI. And the one that probably has been most transformative is the technology-assisted review, this thing called TAR. I believe we're now at TAR 3.0, and every year TAR does advance in the ability of a law firm or just a single lawyer to search millions of client files or files that have been turned over by adversaries during discovery and locate the files that are most relevant. Now that sometimes involves a lot of interaction between the lawyer and the program, but it's way more efficient than having individual lawyers go through each document. And then just law itself. It is very helpful in doing legal research, though again there, ChatGPT is not particularly trained on legal materials. CoCounsel, I think, is better at that, and this is going to get better and better over time. This slide is just a stupid, assertion that I found online. I don't know how much of a lawyer's everyday task AI can do, but that's one kind of assertion. For the actual litigation practice of law, which many of you have engaged in, and I was a litigator a number of years ago, AI does have some very concrete uses right now. It can make predictive judgments. Now, lawyers can do that, maybe still better, but AI can analyze large clumps of data and help lawyers determine, for the plaintiffs, whether to bring suit, or defendants, where to resist, and where to, what forum and what to ask for. E-discovery, as I suggested, is being revolutionized by the various TAR programs. And AI, as Wendell told you, is being used to draft documents everywhere, not just in law. It's being used to draft letters, I think, fairly routinely. I guess it was used to draft the introduction to the entire program. I used it to develop some of these slides. This slide and the prior slide were developed by AI. ChatGPT gave it to me, and then I organized it into slides. But even ChatGPT admits that the human lawyer has got to review these products, as we have discovered, not only because AI produces hallucinations, but also, in my opinion, the ChatGPT cannot do sophisticated legal reasoning. Now, this is stuff I think you probably already know, and here's some more speculative stuff that I guess is beyond the realm of concrete knowledge, at least at this point. And that is, what transformations is this going to effect? One prediction, widely accepted, is that it is going to reduce the need for particularly junior attorneys, maybe reduce the need for attorneys, particularly doing the time-consuming discovery work. Now, I'm a little bit cautious on that because even though a lot of the discovery work can be done much more efficiently, this might lead actually to more discovery disputes, which will involve a lot of lawyer time. But on the whole, it seems safe to say that in the aggregate, these various deep learning techniques will reduce the need for trained lawyers and increase the need for technology staff managers and so forth, and designers, and really increase the need for lawyers who are trained in AI. And various law schools, including Yale and others, now have a lot of students who have degrees in computer science and are already very, very sophisticated at using these mechanisms, much more than the faculties at these various schools. I think it's going to affect client relationships in lots of different ways. The long-term prediction, which is one that we harbor here at Yale, but is widely shared among other experts in this community, is that the AI efficiencies will, over time, undermine the billing by the hour model for client charges. That law firms that can tech up with AI, using many fewer attorneys and many fewer attorney hours on things like discovery, will be moving toward billing by the service kinds of billing mechanisms. Corporate clients, for the most part, I think will welcome this kind of advance, and indeed they will be using AI themselves, maybe to do more in-house work. So a firm that can promise a fixed bill by the service is going to beat out firms that bill by the hour, at least in many cases. So that's our prediction. Our prediction is also that this is going to change the structure of law firms. Now, the structure of law firms has already been highly mobile in the last several decades. And of course, most firms are still relatively small. But the model that traditionally, when I was in private practice, had reigned was this traditional triangle. You have your equity partners at the top, you have associates, and then you have support staff, et cetera, in that large base. Well, that's already changed. You have non-equity partners, you have permanent associates, you have a much larger support staff than you did when I was practicing law. And so maybe a new model of the firm is one where the partners, who might not all be lawyers, by the way, are at the center of the firm. Then you've got a various number of lawyers. You've got a big technology part. And then you have alternative service providers. You might farm out, a lot of law firms already do this, farm out their various requirements. And I think AI is going to make that technology part way more important. I think there will be winners and there will be losers. This is going to shake up the practice of law in a way that maybe we've not seen in the last 100 years. There will be winners, almost for sure. Maybe class action firms, firms representing small plaintiffs, consumers, etc., who find it very difficult to bring lawsuits, particularly in a hostile judicial environment, will maybe find it more efficient to bring larger and larger classes. I think big winners ought to be, and will be, corporate law departments, who can, like Walmart, for example. Walmart can create its own database using not only what's available commercially, but what's called training the database or training the computer model with its own data. Walmart has been sued probably hundreds of thousands of times. They've had complaints maybe millions of times. They have records of how these have been resolved and so on and so forth. All of that can be inputted to create an extraordinarily valuable model for Walmart's corporate law department in evaluating and maybe handling consumer, personnel, and other complaints. I think another big winner will be firms, often big firms, that get the best AI technology early. And by best technology, I mean not only maybe the most recent version of GPT-4, which is only $20 a month, but some of these other mechanisms, and more importantly, whatever they get, they can train with their own data, their own information, and produce maybe a superior product within the law firm. The losers, I think, are going to be big firms that move slowly and stick to the billing by the hour model. I think they're going to lose corporate clients. Ironically, firms that move too quickly and adopt soon absolute tech, I think they will be losers as well. And I put small practitioners in question marks, because small practitioners that get with the agenda of AI, I think, will be winners, but many small practitioners who do not, I think, will be losers. I think most Americans who are involved in litigation, this has been documented, are not represented by lawyers, ironically. And so AI has the potential of expanding access to justice, either to people who don't bring legal complaints but have legal grievances and cannot afford an attorney, or people like tenants, etc., who are brought into court involuntarily and don't get a lawyer because they can't afford one. And AI has the potential, and emphasize the potential, to expand the availability of legal services to an unserved or underserved population. And we've already seen that. There are websites already that provide basic legal information and answer routine legal questions from laypersons, sometimes from lawyers. I think we'll see AI used maybe unevenly by legal aid, law school clinics, and other nonprofits who can use AI to help screen and inform clients, client triage. They can use it for information gathering, preliminary drafting, and legal research. So in other words, understaffed and underpaid legal service organizations might find AI to be very beneficial. You've probably heard of, and maybe have a dim view of Do Not Pay, where an AI program, quote unquote, represents people, originally in paying parking tickets and does legal filings for them. Do Not Pay has encountered a number of quality control problems, to say the least, and ethics problems. It's being sued in California for violation of the California unauthorized practice of law statute. There is our little robo-lawyer. I think AI offers a number of challenges for the attorney who uses it in terms of legal ethics. In Connecticut, Rule 1.1, the comments to it, do say that lawyers are supposed to keep abreast of technology. And this technology, I think, is a train that is not going to stop. So sooner or later, you're going to have to. If you do use AI, however, you're going to have to communicate this to the clients. And the clients also probably need to be told about the possibility, if you use a third-party vendor, it's quite possible that the vendor will have access to client information, and you need to get consent from the client at the very least. I throw this out as unanswered questions, at least in the courts and in my own mind. In litigation, does a lawyer have to disclose their seed set of documents to the other side? In other words, what is the mechanism we use to identify the documents that we're handing over? What is the status of AI technology and the training of that technology and the fine-tuning of that technology in terms of property? Is it qualified as a trade secret or product or what? And we do not have answers to that at this point. Lawyers, as you know, do have duties of supervision, which are very, very important. And these are some of the Connecticut rules that are relevant to that, it seems to me. An important thing is, if, as the lawyer did in New York and other lawyers have done, you hand in a document that you've not carefully checked, AI's hallucinations and mistakes are your mistakes. Very importantly, I think, and this is addressed to the Connecticut Bar Association itself, that some of our rules are going to come under pressure from AI. So 5.4, which prohibits non-lawyer ownership, equity ownership of law firms, I think is going to come under pressure. AI can be very expensive if you want to create your own. I think there will be pressures for law firms to raise money for it and even to introduce technocrats and whatnot as partners in the firm. That obviously puts pressure on 5.4D. I'm a member of the DC Bar, and we've already changed our 5.4D to allow ownership by non-lawyers. We have a statute as well as Rule 5.5 that prohibits the unauthorized practice of law. This might apply to Do Not Pay, but it also might stymie AI programs that are targeted at unrepresented litigants to defend themselves against repeat players. So that's a problem of equity, it seems to me, that the bar needs to address. In closing, let me just say a few words about how AI will transform legal education. And this is already happening. In terms of research, when I was in law school, we just pulled the books off the shelves and read the cases. That's long ago obsolete. And Westlaw and Lexis are now primary research methodologies for law students. So you don't see them in the libraries anymore. They do it on their laptops. But law students are already moving to the next stage, and they're already using GPT-4 and even co-counsel and other mechanisms to do legal research and even to do legal writing. At Yale, we've done for a couple of semesters now an experimental course on AI and the legal profession. And Jeff Chivers and Theo Rostow, two lawyers, and I will offer at Yale in the fall of 2024 an experimental civil procedure small group where all of the work will be done on an AI platform. And I think that is going to be a very important step for Yale and perhaps for other schools. I think a step we all should have been taking 10 years ago is that all law schools ought to, though they do not, introduce AI to the first-year students. Here's a little thing of our class. I think AI is going to more dramatically transform legal education in terms of how we teach all of the courses and how we do clinics. Most law schools not only have clinics, but they have more clinics now than they once did. And I think AI will facilitate the clinics that we do have and offers the opportunity for Yale and Georgetown and Connecticut and others to expand their clinics into law school-supported websites for the public. Now that again might run up against the unauthorized practice rules. So on that note, I will conclude, and with thanks again to the Connecticut Bar Association for hosting.
Thank you very much. So we've had a couple people who've seen Professor Hinton's interview and wondered if either of you have any comments. In particular, one question sort of beyond, like, in addition to that is do you feel that AI could become sentient? Excuse me.
Right. I have been in this conversation now for 20 years. It keeps coming up in dramatic forms every time there's a new breakthrough. And I generally characterize my position as the friendly skeptic. Friendly to the can-do engineering spirit that remarkable things lie in our future, skeptical that we know enough about intelligence, understanding, consciousness, and other qualities that we can actually emulate those within artificial intelligence. So with due regard to many people in the AI industry who believe we can, I think there are qualities that come to bear that are not fully understood and not fully addressed by the science we have today. And there's a particular mindset that tends to dominate the Silicon Valley way of looking at the world. A kind of hegemony of what I will call a kind of reductionistic materialism, that everything can be reduced, that all information, all knowledge, everything about us can be reduced to bits of information and emulated within both the human biological system, the computational theory of mind, and can functionally be emulated within other systems. Now, let me say one more thing in all that regard. Because a lot of the AI researchers who put superintelligence, much smarter than human machines, might create existential risk, who put it off 40 or 50 or even 100 years, are reassessing that since ChatGPT. So we are at a moment when the computer scientists are reassessing their position because they were surprised to see that machines could be so functional in these ways. But I think we're still a long ways from machines truly having understanding, semantic understanding, and the emotional intelligence to give them the ability to actually appreciate the meaning of a lot of the concepts they're throwing around.
Thank you. Professor Eskridge, any comment?
I refer, there's some wonderful interviews with Noam Chomsky, who dismisses AI, I think, too quickly, as just an accelerated vacuum cleaner. He says, well, it's very useful, but it has a relationship to human language that a vacuum cleaner would have to a human being operating a cleaning service. And he thinks that human innate intelligence, innate hardwiring in our things is not replicable by the current AI technology. Now, most people think that's too dismissive, but he is making a very valid point that I think Wendell is also making. But the only point I would make is there are going to be new developments. The neural networks technology we have now, which is improving with more data and more training and more this and more that, there will be another jump in the next decade, maybe several more jumps, that will bring AI closer to the human brain. So stay tuned.
Let me add one thing to that, okay? I agree that we are going to see continual breakthroughs, and then there's always this question of how close you get to what humans are exemplifying. But I think the question we really should be pondering is not whether the machines are going to be sentient or conscious, or even have understanding, is whether it will make a difference. Whether we will implement them or allow them to play roles in critical decisions, regardless of whether they have a full appreciation or a human-like appreciation for the decisions they're making. And that's a discussion we have to have, and that should feed into the policy discussions about what we regulate and don't regulate.
Yeah, a minor addendum to the policy discussions is there's already a legal literature developing on is artificial intelligence a quasi-person? Animals, there's a lot of literature on, are animals quasi-persons? Do they have rights? In some cases, yes. Even dead bodies. It's amazing in Connecticut and other states, dead bodies have a lot of legally protected rights. And so we're going to be confronting that question, I think, also with AI. The law professors are already writing about that. And we will see, to what extent Mr. Data on the Star Trek series represents the future or just a fantasy.
Thank you. One other question we have from the audience is, if young lawyers will be the losers from AI, who's going to be going to law school?
Well, I think the thoughtful undergraduate who's deciding whether they want to go to law school, there are a number of lawyers who don't get jobs currently. That's always been the case. And who end up doing alternative careers, including real estate, for example. Well, real estate is going to be AI. So the advice that I would give young lawyer aspirants, I guess, is that you probably do need to learn something about AI and computer science in undergraduate school. And then when you go to law school, the lawyers who will, I think, be preferred on the market are going to be lawyers who have AI training. So that's number one. I think number two, the good news maybe for these lawyers is they will not be doing drudgery work. I mean, the nightmare scenario for a young lawyer is to be sifting through millions of documents by hand. It's very boring, it's soul-deadening work. They will actually be doing more creative work. And here's a kicker, is a lot of the lawyers coming out of law school, most of them, in fact, will be more qualified to deal with the new AI environment than the old folky lawyers who are running the law firms. So think of it this way. If I were advising undergraduates thinking going to law school, think entrepreneurial. Think in terms of what you can do with the degree, including creating your own AI law firm. The folks that I'm teaching my course with, Theo Rostow and Jeff Chivers, are recent graduates of Yale and Georgetown law schools, respectively. And they started their own AI law firm, and they're doing really quite well. And they're going to be a very successful enterprise. So you don't need to join, some, huge labyrinthine law firm to have job security. That might be the exact opposite. That you might have more job security in your own firm or in a young firm that's already using AI. So that would be my advice to them. Yes, we should all be very concerned because the future is now much more in flux than it was in the last century.
let me pick up on that a little bit, because this is a subset of the technological unemployment question. And for 200 years, we've had the Luddite fear with each new technology that it would replace more jobs than it created. And for 200 years, there's been a gap. It does destroy jobs, and that creates difficulties for one generation. And in the next generation, there are new tasks that they might do. But the question is whether we have now, at this point, altered the basic political economy of all of that. And not just because you now have something like generative AI that we can foresee how it could replace many jobs, not just in the law, but in all kinds of professions, whether we're actually going to see that occur, and whether that will actually be driven by the fact that we have created an economy in which 70% of all productivity gains go to the owners of capital. Excuse me. 70% of productivity gains go to the top 1%, which is the owners of capital who own the most stocks. Now, most of you in this room probably own stocks, so you're getting a little bit of benefit of that. But as long as we have that, every job that goes to AI or a robot, then 100% of all productivity gains go to the owners of capital. Nothing goes to labor anymore. And so I think we have created a geopolitical and economic situation at the moment that we will see exacerbations of technological unemployment over the next 10 and 12 years.
Thank you. Another question. We've been talking a bit about the lawyers' use of AI. What about the courts? What are your thoughts on the use of AI by courts to decide motions and cases? Would that create...
Yeah, if you actually talk to judges, judges tend to be old, sclerotic, and technology resistant compared with lawyers. And I must say law professors fall in between. We tend to be old and sclerotic and technology resistant as well. So, you know, in some countries like People's Republic of China, they're way ahead of us in using AI technology in courts to streamline proceedings, to process facts, and so on and so forth. I think not to decide cases, more to monitor what judges do with cases. In the United States, at the federal level, very little is being done. I've been in communication with the Standing Committee of the Rules of Civil Procedure, and they are not, in any time in the near future, going to be addressing AI issues. A lot of it is budgetary. If the US Congress, which I realize now is at a standstill and has been gridlocked for some time, if the US Congress delivered a potload of money to the federal judiciary and said, only those district courts that use this to modernize and use AI can get some of this potload of money, I think we would see some action at the district court levels. But so far, most of the action has been by law clerks who use GPT-4 to draft things for judges, presumably with some disclosure. I think GPT-4 would be invaluable in drafting jury charges if a judge could train it on the charges that the judge has used previously or other judges in that court. But they've been slow, I'm afraid. At the state court level, I think there ought to be more promise, because in many states, maybe not Connecticut as much as some others, the trial and intermediate appeals courts are backlogged with way too many cases. And AI could theoretically, I think very practically, serve triage and caseload management purposes for those courts. But I don't see that really occurring very much. Unfortunately, the judiciary at this point is more of a roadblock to AI development because to the extent the judiciary is ultimately in charge of the Bar Association. And in some states like DC, not a state, but in DC, the unauthorized practice of law regulation is mainly by the Court of Appeals and not by the DC Bar, though it does have a Rule 5.5. And I see no movement at this point in most of those court systems to allowing greater access for unrepresented people through these AI platforms. We have seen some progress in Arizona and Utah, very red states. And I understand the Supreme Court of Texas, a very red state, is also considering opening the portals for use of AI on a limited basis by unrepresented people. But in blue states, like California, the plaintiff's bar has been very resistant. So it's very frustrating that as AI is transforming the practice of law, judges are going to be caught flat-footed. And here's one inflection point. I said earlier that in discovery, TAR does make discovery a lot easier for big document cases. But there are also, lawyers being lawyers, there are also going to be increasing numbers of disputes about the TAR that is used, how the seed set is created and prompted, how it's fine-tuned, and judges are going to have to resolve some of those controversies, and judges do not have a clue about how to resolve TAR methodological controversies. Now, in the federal system, they often refer these to magistrates who are sometimes equally clueless, or they can appoint special masters. So I see a huge bollocks for the judiciary in America anyway. People's Republic of China, okay. United Kingdom, already there. United States, very backward.
So let me add a couple of things here. I think one of the things we have perhaps been missing in our two presentations this morning is the focus has been on how AI is going to change the practice of law. It is not, we have not been focused on how AI is going to be the focus of the practice of law in many regards, particularly as we sort through what kind of regulatory frameworks we're going to put in place. Now, the U.S. is particularly inured to wanting to put regulatory frameworks in place because it says it interferes with innovation and our competition with China. You know, you all know the basic arguments there. But I think we're getting into situations where there are actually going to be more and more violations of people's rights and more tragedies happening because of things that AI did. I won't say that AI did it without the involvement of the humans who oversaw that AI, but at the moment there's almost no accountability. We have things like 230, which gave basically the corporations carte blanche with social media and with other technologies. So we are going to have to look a bit more at accountability, and the practice of law is going to open up all kinds of things for lawyers to do that they bring to court around the way in which AI itself acted. And that's going to, again, precipitate the need for judges to know an awful lot more about what AI is and be able to think about these problems. Now, this isn't the first time we've had this. We had this 10 years ago with neuroscientific arguments that, for example, that people did not know what they were doing. And that required a tremendous amount of re-education for judges in those practices. I also want to just throw in one little tidbit here. You mentioned Arizona, which is essentially a red state, though it's a little complicated at the moment, given that it has 1.5 senators who are Democrats. But I think what we sometimes miss out on with this great august university, Yale, here, that we tend to think of Yale as the center of the universe. But in Arizona, you have the center of the A. O'Connor School of Law. And you have Arizona State University in general, which is actually the leading university in the country as far as thinking about the ethical and legal ramifications of emerging technologies, particularly AI. And Senator A. O'Connor Center has been at the forefront of many of the very things that we are talking about here, and it's one of the reasons why some of these laws already exist in the state of Arizona.
Thank you. I know we go on for like a lot longer, but I promised Ernie, since this is the very first panel, I'd keep this on time. So with that, I'm going to have to say thank you very much to Professor Wallace and Professor Eckery.
All right, thank you. Thank you very much. I think we're still waiting for our AV guy, but we'll pass the mic while he's coming. This section is, we were kicking around what would make this a useful and meaningful seminar for the lawyers who practice on a day-to-day basis. So we researched and we got three really, I think, good people who have different focuses, but they're all focused on the practice of law and the practical aspects of using AI in it. Now you can look at using the QR code, which we all thought was really technological. Some of us can actually do that with our phones. Others of us are still trying to master that. But, so I'm not going to spend a lot of time introducing these folks other than a little bit. We're going to start off with Ryan McKean. Ryan is a member of what I think is really the next generation of lawyers. People who've already moved into the idea of using this stuff and have been very successful in doing it. And then Jackie and Gabe and Ryan are going to engage a little bit of discussion about his presentation. We'll move on to Jackie and then Gabe. And I think you'll see that we'll have a robust discussion. We welcome questions. I have learned to text, so my text number is on the, whatever you call this thing, the schedule. So Ryan McKean, our $100 million man, will lead us off. Thank you, Ryan.
Well, first of all, thank you all for having me, and I'm just really honored to be here. And we have a tremendous panel of just people I respect tremendously. So I look forward to talking about artificial intelligence on a very practical level in our firm. I am the CEO and co-founder of Connecticut Trial Firm. At this point, a lot of my job is frankly putting the best tools available in the hands of our lawyers that serve our clients. And that involves a lot of usage of artificial intelligence, figuring out how best to implement that, and figuring out just training, essentially. Because look, one of the great promises of technology is that it would make life easier. In fact, I don't think life has become easier, we have just become more productive. We have more work, and there are reasons for that. There are demographic trends at play here. There is a permanent labor shortage. Every law firm that I know, I've talked to lawyers from around the country, is having difficulty hiring. That is the #1 concern of law firm owners, hiring. I know last year, I think for the first time ever on the Connecticut Trial Lawyers listserv, there was a post put out that said, hey, if you want to be a judge, please, now's the time to apply because there's a shortage of people who want to be on the bench. And there are reasons why law in particular has this I think, profound issue, because our regulatory structure has become increasingly more complicated. Society has become increasingly more complicated. I graduated law school in 2005. In 2005, there was no social media really. There was no cryptocurrency, there was no Bitcoin. If you practice cannabis law, you weren't representing real estate developers and business people, you were representing drug dealers. And so just the environment that we operate in, as you can see, you heard in the first presentation, now the regulation of AI, well that tremendously exists, but I can imagine a limitless future for intellectual property lawyers. So we're in this space where how are we going to meet increasing demands? I as a business owner, and I look at it as a business, and I look and I see the Connecticut bar passage rates. And I think this year was something like 330 people were admitted in this July. Right now, are being sworn in the next few weeks. When I was there, it was something like 920 in 2005. That is a problem for people in this room. That is a problem for our profession. That is a problem for the public who will not have access to lawyers. So what is it that we, this is where, to me, artificial intelligence comes in, because how are we going to essentially do more with a lot less? How are courts, lawyers, businesses going to do more with less? And I think fortunately legal, in a lot of respects, is you take information from one source, whether it's records, discovery, you process that information and then you do something with it. It comes out in the form of a brief, or if you are a judge, it comes out in the form of an opinion. And large language models are incredibly adept at that kind of thing, understanding relationships between words, essentially, and doing some predictive analysis and sorting through large amounts of data in a very prompt way. Do you want me to keep going, Mark, or do you want me to do a sentence introduction?
No, keep going.
Okay.
Tell us how you use it in your firm.
We, right now, we use AI a lot in terms of the summarization of documents. We are a personal injury firm. We deal with loads and loads of medical records. And those medical records do lend themselves to being able to be digested by AI. We can pull codes, we can see future treatment, we can see surgical recommendations, we can see those things. These are things that typically either a lawyer or an associate or a paralegal would spend hours each day sorting through meds and then doing a med chronology and trying to figure that out. We are using it to identify issues. We are using it also most recently to do things like summarize what is going on in a case. We have an AI-assisted bot in our case management system that's saying, well, what are the things that have happened in this case? And eventually those bots are going to be more powerful, and they're going to say, hey, this case has been here, and I am seeing that the insurance is this, or the client is done treating, would you like me to draft a demand letter? Would you like me to start drafting a complaint? Where AI is going with us is a very high quality assistant. You were talking, I think, at the level right now that we are receiving of somebody who's probably a fifth-year lawyer being able to summarize these things. And that is being taken off the plate of our lawyers, who also have a lot to do, in allowing them to make decisions that are strategic in cases, allow them to communicate and connect with clients, allow them to better hone their skills by going to trial schools or doing these other things, because their time is not spent summarizing. We are using AI most recently. One of the things that we get is we get a lot of calls into our firm of people looking for legal services. And we have people who are trained to listen to those people, try to get information to figure out if that is a case for us or not. And so they're trying to take notes, and they take notes that are like, hey, they're almost scripting what they're being told. We have AI that does scripting on our phone calls as well. But AI can now functionally say to take all their different data points and create prose from it. Prose is much more useful for humans to read and summarize and do something with than before. Create that prose and then push it into our case management system. Also using it for predictive analytics to say, is this a case that we may want or not? We have used co-counsel by case text as well to start legal research. Oftentimes what we talk about in our firm, what I talk about a lot, is sort of AI in the concept of 10-80-10, where lawyers at this point really need to be thinking about, like Ernie and Mark talked about, the prompts to be asking, where the inquiry needs to be, why they need to be doing that inquiry. AI can then do a lot of the work, the relational work, finding the cases, understanding the arguments, uploading a brief and understanding these things. These are all products that exist today that are commercially available. And really then the job of the lawyer becomes, like the last one of the slides says, is anybody, the Einstein quote, to understand that and then to advise on what it is that means. And so what we're trying to do is free up that time to eliminate a lot of the mundane, give our lawyers a good start, and I constantly challenge them, Mark, to think of AI not as software, but to think of it as an assistant, and to use it as an assistant that can be incredibly capable.
You and I were discussing in anticipation of today your incredible verdict. And you mentioned the fact that you had done 12 mock trials before that you got that verdict. And then you started discussing the use of AI in jury selection and mock trial. Could you expound upon that a little bit?
Well, yeah, I mean, the development of legal tech in the past year has been profound, and AI has been profound. I mean, right now we are looking at technologies that can help identify tones in emails and text messages, and to identify clients that may be upset or opportunities that we may need. You may want to call this client. But what we have done, what we did with our $100 million jury verdict, and what we had done at that point was we used a lot of Zoom to record focus groups. And these really aren't mock trials. It's just like, hey, how did you think this happened? Here's this witness. What do you think about this? And what we were doing was scoring those jurors and scoring them based upon their responses, and then using that data to understand which jurors we may want on our case or not want on our case. What we're starting to see in the trial space is just that, which is, you have, as we talk about lawyers using AI, you have marketers out there who are incredibly incentivized to use AI to figure out who might be likely to buy something and why they may be likely to buy it. So what you're starting to see is the use of large-scale data, language models that are primarily trained on social media. The data that you've been giving to Facebook is Twitter and all these other places is where that they are training this. And so to help understand what jurors are favorable or unfavorable to you and why they are, or what arguments that they may be receptive or not receptive to you, that is where our trial team and where our litigators are thinking about this problem, and where we're looking to identify software solutions for it, because it can be very expensive and time-consuming to run the focus groups.
So I don't want to dominate this, and I noticed that your other two colleagues are nodding along, so either Jackie or Gabe, do you have any comments on Ryan's use as kind of a thought leader on this, or actually a practice leader?
Yeah, I mean, my immediate thought is that this is exactly the perfect example of how you're using AI to win and to be competitive. And so I think we're going to start to see what was discussed in the last presentation, that the winners and the losers, if you want to get in a position where you just have a huge tactical advantage over your opponent who's still using paper and pencil, that this is the time to dig in. And I think the other thing that really strikes me about how Ryan runs his firm is that it's sort of like it's a fearlessness of not being afraid that it won't be perfect, or that it won't be exactly what a lawyer would create. But look, let's try it. Let's see how it can be helpful. And I think that's where we can sometimes struggle as lawyers, where we're looking for perfection before we even consider doing anything differently. And so that's not where we are with technology. I think everyone needs to get in this more flexible mindset of try it. See, maybe this use of AI is not going to really move the needle for your practice, but maybe it's in jury selection. Maybe it's in helping you with your table of authorities. Like, there's all sorts of different ways you could be using AI right now. And so standing on the sidelines is not going to be a great option.
Okay.
I'll introduce the idea more fully in just a few minutes, but I'm struck by how well Ryan and team integrate people, processes, and technology. So one of the challenges of cool technology tools is that in isolation, they're not very useful. You need an alignment. You need the right people, you need the right application, the right processes, and the right technology. So I suspect the story of what they're doing there is not just about the AI, although that's part of it, that's the technology part. It's this broader approach that makes things like this work. And one of the things I just have to remark, in chatting with Ryan, I've realized how savvy he is, not just about the practice of law and running a wonderful firm, but about telling the story. I had the opportunity to meet his colleague, Brittany, this marketing person. And if we take a step back and we think meaningfully about what it is to deliver legal services, it's not just about what you do in the courtroom, it's not just about how you counsel clients, it's about how you tell the story. And you need to have that alignment, which Ryan and team have really done in a special way.
You know, I think it's, I think it's, there are, we use very specific AI tools for legal, and, you know, Jackie's like Clear Brief is an incredible example of a tool that I think is just, is very powerful. But there are, you know, I mean, we talk about AI in legal, like the truth is that we are all using AI every single day without probably even knowing it. And I can tell you just some other examples of baseline AI that you might not think of that we use right now. We get calls all the time. You're a personal injury firm. We get calls 24/7. We have an AI answering service that will answer the phone. So like if you called American Express, for example, you don't get a person. It's like, hi, this is Bob, your assistant. How can I help you? And we use AI to do an initial intake and then properly route the calls, get the information that goes into our lead management service, and if appropriate, route it to an attorney or one of our intake specialists there. I've done a slide deck using Google Slides, and I've said, I want to create a slide deck that does this. We use AI summarization. I know Ernie got a kick out of this. Fireflies.ai that goes into Zoom and just summarizes things. So when we do calls with clients, we are using AI summarizations as opposed to taking notes, which allow us to be more present. I use Grammarly. My grammar is not great, but Grammarly makes me write really well. So things like that are available. We use Loom.ai to do training. I tend to say and edit videos, and Loom can condense it, take those things out, and does it just automatically, seamlessly in the background. We do podcasts. We can get studio quality audio without being in a studio from your iPhone by using Adobe's Podcast AI. That makes it sound incredible. I mean, really, the options here are limitless, both within legal tech and I think without, and you're looking at broad adoption of products where lawyers work, in Westlaw, Microsoft, Google, all of these are coming in to take your data, collaborate, and do it. We also do extensive data analysis of our firm, of what's going on, where are we getting the phone calls, when. And AI is a part of the data visualization and the data production, and putting the data in the hands of our decision makers.
One of our attendees texted me just now on that very issue to ask you about, as a firm leader, how do you use AI in management of the firm?
In management of the firm, I mean, primarily it is through the collection and automation of data and the visualization of data within the firm. How many cases do the lawyers have? Where are the cases? What are the statutes coming up? How long have the cases sat? You know, what we're using AI, we're about to be able to use AI through a portal that we set up for our clients that will translate 180 languages instantly. So if somebody is speaking Chinese, or Mandarin rather, it will appear Mandarin to them and English to our team. I mean, that is a profound ability to influence the access to justice by allowing us to provide services to others. We can track trends in our client success scores using AI as well. I think for me, at the biggest point right now is figuring out the technology, the appropriate implementation, leading that technology in our firm, and primarily using it for me at this point, for data to figure out what to do next.
One of our attendees says, as House counsel, I have to decide whether to sue or settle matters on a daily basis. What metrics, data points, or information does AI use, and how do they make that decision?
Yeah, you know, we've used services to try to evaluate cases using AI, and frankly, I think a lot of it is garbage, because this is where it gets, I think, really important, and where like the sort of next level is. I don't necessarily care what some other firm is able to do on a similar case. Maybe I do. I want to know what our lawyers and our firm is able to do. Can we do it better? And so when you have AI trained at data at large, like, well, yeah, you're taking maybe an average, but maybe your firm's not average. Maybe you're below average. Maybe you're above average. And so where it's not at the moment is being able to train specifically on your data sets. Probably be a lot because it's too small, a lot because the technology is still too new, but it's very easy for me to imagine in the conversations I've had with tech leaders that in the next 6 months to a year, that is going to be accessible. So the results your firm gets on particular cases will be available to you.
Also, the demo I'm going to show in a sec can also show you how you could use it now to just give yourself a quick sense of the facts so that you can help make those decisions.
Well, that's a good intro for Jackie Schaefer, who gets the award for coming the farthest today, all the way from Seattle. She founded a tech firm, and she'll explain what it is. I asked her, I said, can I describe you as a member of the sorority of girls who code? And she said, no, I don't code. She says, we have somebody who codes. She's the visionary, so Jackie.
Thank you. And actually, could you mind handing me that mic?
Oh, sure.
Yeah, I'd like it to stand up for a second. Okay, wonderful. Yes, thank you so much. I'm Jackie Schaefer. I'm a career litigator. I started out at Paul Weiss in New York, spent most of my career in government as an assistant attorney general in Alaska and Washington State. I regularly argued before the state Supreme Court, the state appellate courts, written attorney general opinions. I have tons of motions, briefs, and had the experience so many times of I absolutely love the legal writing process and all of the theory and the strategy that goes into how you tell your client's story. And what I hated was all of the stress that came with the days leading up to filing something, and how there was all this, just always, no matter what, a scramble where you're trying to get your exhibits done, you're trying to get your table of authorities done, you have to check every citation, and of course you always, after you file it, you always realize there were like a bunch of mistakes that you missed, and it's incredibly stressful. So I actually founded Clearbrief in 2020. So that was like 1,000 years ago in robot years. And AI was still very sketchy. Even in actually the venture capital world, I'm one of the fewer than 2% of women-led companies that raise venture capital. Woohoo! So, in 2020, I had this insight that I was learning more about artificial intelligence. There's actually a law in Seattle that if you live there for a certain amount of time, you have to found a tech company. But I do think that, quite honestly, I'm from the East Coast, I'm from the Philly area, and living in Seattle, I did get exposed to a lot of new ideas about artificial intelligence. And I remember at one point, I had a friend of a friend meet me at the downtown Seattle courthouse, because at the time I was in-house counsel and I didn't have access to Westlaw. And so he met me there, and I showed him some case law, and I was like, do you think that this is like structured enough data that AI could do something with this? And he was like, yeah. And that was enough for me to be like, all right, I'm gonna start a company. And anyway, there's a lot that led to starting Clearbrief, and I'm so proud. We're now used by hundreds of law firms across the country, including the largest global law firms. We're used by about a dozen courts across the country. So I vehemently disagreed with the first presentation's discussion that courts are a blocker for AI. I sit with judges all the time and see them using our AI, and I'm going to show you, because I felt like one thing I could contribute to this discussion, for those of us who are more visual people, visual learners, I can sort of show you, we're talking a lot about AI, the impact, and that sort of thing. So I want to actually just take it to the screen here. And I'm going to walk through what Clearbrief does and what generative AI does for legal writing. Just give it a sec here. I think it might need to turn on. It was working a second ago. Well, let's try this. All else fails, you can.
The only thing I know is if you turn it off and turn it on, that cures all computer problems.
It really does. Well, let's give it a sec here. And maybe we can get the AV person. person. So just to, talk through this a little bit, one of the other big insights I had was that if you are going to get lawyers to actually use AI, so I actually started off thinking, oh, we'll build our own standalone platform, everyone will start writing their briefs in our platform, and then I realized the only technology that we know how to use somewhat is Word. So if we can bring AI into Microsoft Word, that will, actually help give us a leg up. So that's what we did. You can use our AI in a number of different ways, and so I'm going to start by showing you a new feature that we actually just released in August that uses generative AI. So one of the first things that I do when I get a case, and this is speaking to the last question we had about the in-house counsel, where I was in-house counsel for several years, actually, in there, where, oftentimes the HR department, for example, will come to you and say something like, hey, so we're gonna fire this woman. She told us she was pregnant, yesterday, and she won employee of the month every month for the last year, but yeah, she's just a really bad employee now, so is that good? And you're just like, can you send me some of the, performance plans, some of the emails around that? And you need to quickly, get a sense of the evidence and make a coherent recommendation to your client about what to do next. So a version of that happens in, anything when we start to get discovery in. So this is how you use ClearBrief to create an instant hyperlinked timeline. So by the way, let me just show you kind of from the beginning. You could start with a blank Word document. ClearBrief is this little icon in Word. You drag it over so it takes up about half the screen here. And you would start a matter folder. I've already started one. So I know everyone's concern when they think about AI is hallucination, right? That the AI is going to invent something and it's trained on, the internet, and did it stop in 2021? Our AI is designed so that it's focused on your source documents. So here is where you can upload whatever discovery you have, your medical records. We now have several partnerships, which is exciting as a small, scrappy startup, with Clio, NetDocs, Relativity, iManage. So I pulled, a bunch of medical records that are publicly available from the internet, and I'm going to go to this hyperlinked timeline feature. So when I select the documents that I want to be included in my timeline, this is how it takes, about a minute. The AI will go through those documents. It will identify anything that's a date referenced in my document. And that also includes implicit dates. I've seen it work really well with transcripts where a witness is like, well, 3 weeks ago I saw somebody blah, blah, blah. And then it will figure out what 3 weeks ago was. But again, the AI is only able to pull from what you've uploaded into the system. So now it is telling me to click over here into my Word document, and I click Done. And boom, that has now made me a hyperlinked chronology. And this, again, is super, super important for understanding, my vision for AI, is I don't trust anything, right? As a lawyer, I have a terrible, ability to trust. So you can see what ClearBrief did was it extracted all the dates mentioned. The AI wrote a summary of what happened on that date. So John underwent left total knee arthroplasty at the hospital for special surgery. And then it included a citation. And it's showing me the page where it got this information. And the AI is also highlighting in blue, see? This is the AI, showing me why it's recommending that summary and where it got that summary. So I can verify, yep, January 14th, 2014. And, it makes it so much easier for me to, do what everyone's telling you about AI, which is, you can use AI, but you have to check it over. You have to supervise it. You have to verify it. Well, in practice, I found it's hard to do that if the source documents are not easily accessible. So that is really the whole theory behind our platform, is that it makes any citation easily accessible. And then I want to show you just a couple more examples of how we're using a type of AI that's called semantic similarity. So we hold 4 issued AI patents. So I may not code, but I am a inventor of 4 patents. Woo! Along with my chief technology officer, he was at Microsoft for 20 plus years, leading AI. But really, to build this product, you need both. So if I'm starting to write a brief or a motion, I have to know what themes I want to talk about. So at this point, I think it's quite difficult for the AI to actually, figure out the whole theory of my case. The AI does not know what this particular judge is going to be responsive to. I'm sort of working with a lot of different sources of information from my career as a lawyer to come up with the theory of my case. But I've read the record, and I might start by doing an outline like this. So I'm going to upload my source documents and go click my Analyze button. This is our little AI avocado being. There's no explanation for this other than I just was like, I want to put fun cartoons in my product. And it does make people smile. Okay, so see, if I have a citation to the facts, ClearBrief will do something very helpful. The AI scans your document and it recognizes all the citations and will display the source. So that alone, that's AI. So even if you don't like any of the other generative stuff, you could see your evidence while you write. Now the AI is also giving it a score. So see how these orange bars here? It's kind of hard to see on the screen, but it's reading what I wrote. The governor discussed infidelity and whether she had cheated on her husband, and it's reading the text on this page. Do you think that this appearances page is going to prove to the court that this is a good site? No. This is just an appearances page, doesn't mention the governor. So then the AI is making suggestions for me to better evidence that could prove what I'm trying to write across all of my different documents. And so the first suggestion here is to the AG's investigation report. The governor called her and Miss McGrath Mingle Llamas, inquired about cheating. So I can select any text because ClearBrief has made this text searchable as well, and paste this in my document. I can continue drafting. So some of the judges that I've worked with, I've seen them use this. They sort of know the findings that they want because they were there, obviously, at the hearing. They know what they want to put in there. And they just need to back it up with where somebody said this in the record. And they can easily now insert, see this plus button? They can insert a citation into the document. And this allows anyone who is looking at your brief or your motion, you can share this with other people at the firm so that they know that you did not hallucinate this information, they know the source. Here's an example where it also automatically detects citations to the law and displays them automatically. You can just click in any citation and it will automatically show you the source. If it's a fake case or something where something's seriously off about the case, it will do this. Well, we couldn't find this. So finally, the last step of using ClearBrief is this hyperlink ability, so that whatever you're creating, you can, I already just have one up just for time here. You click that button, it takes your Word document, and it makes it fully hyperlinked. Because this isn't just about us, the lawyers, this is about our audience, the judges. They are worried that this is a fake case, that the evidence doesn't say what you're claiming it says. This is a real Ninth Circuit brief that we just sort of ran through ClearBrief. But it will display, this is like, the factual record that's being cited. It's so much more powerful to be able to tell your story with evidence to the judge. And so I hope this sort of just gives you, it also instantly does your table of authorities, because there's no better use of AI, in my opinion, like global warming, whatever, like do my table of authorities. It's just a nightmare. So this is though how AI is being used right now, today, for these types of tasks that don't usurp the lawyer's judgment. They're not telling you what to write, they're not writing the whole case for you, but they're giving you a really massive advantage in terms of time savings and in terms of showing the transparency of your evidence.
Jackie, we had a question from the audience, which, you don't know, but some of the audience does. For the last 20 years, I've been involved in lawyer ethics. And when you put up these medical records that you got from the internet, I'm like, bingo, okay. So the question is, how much, if I start uploading my client's information, can you see it?
Yeah, great question. So by the way, I also went in and redacted those, even though they were from the internet and they were already redacted, I think. We just redacted them again. So one of the things that's unique about my company, because I'm a lawyer, I knew from day one that we would not be successful in selling this to courts, government agencies, law firms, unless we met the strictest security and confidentiality requirements. So we went through a process that's called SOC 2 certification, and we're SOC 2 Type 2 certified. There's very few, even these massive companies that meet that standard. So what that means is that we're not only required to have all these security controls, we're audited on them as well. So when you upload something into ClearBrief, it's stored in our secure cloud, and no, it's just in the cloud, protected, and it's not compromising your client's confidentiality.
Well, I saw, well, I'm sorry, Ryan, go ahead.
That's a really important point for me as a consumer of this, is like I do not touch generally consumer, like ChatGPT for legal, other than using it for prompts for maybe ideas, like what questions interrogatories would you recommend for like a dead body case, dead body rights. But really the SOC 2 compliance, SOC 2 data compliance is sort of a gold standard that you should be using, and really the technology, if you're not paying for it, like you are the product, it is training on your data.
Yeah, I saw
100%.
the other day Senator Menendez, one of the things in his indictment was the day he allegedly received a gold bar as a bribe from some foreign government, he Googled how much is a gold bar worth. So my concern is, because look, the technology, in 10 lifetimes I wouldn't know what this panel knows about technology. I would just go to ChatGPT and say, my client killed somebody, what's a good alibi? And my client's named Ryan McKee.
Actually, one more thing I want to mention about that. So all of our AI has been to date before that latest feature with the instant hyperlink timeline was running models that we've run internal to our whole ClearBrief ecosystem. The exception to that, and that's why for that hyperlink timeline, we are requiring our customers to opt into that feature, but it uses Microsoft Azure's GPT-4 API, which just basically means like it connects to GPT-4 through Microsoft. And we have a special partnership with Microsoft so that they don't save any of the queries, nothing is saved. There's also a content filter exemption, because the average company, if you tried to send like, a child welfare case record, it would be like, this is, horrible, subject matter, we can't do anything with this. And we know that as lawyers, we often have very, troubling source documents to deal with. So anyway, the point is, our product, nothing is saved in terms of your queries, that sort of thing, when it comes to using GPT-4. So I think it's really important to experiment with AI technology. Just make sure that you're using a trusted company and one that was built for legal use. That's really my best recommendation, because the average ChatGPT, is not going to be designed for the level of security and also just the workflows that we have.
And commonly for products built for legal use, it's not training on your data, so it's not saying like, other ClearBrief user can't understand what I've done, because it's not like, hey, what did Ryan type? And
Exactly.
the AI does that. It doesn't train, it doesn't store your data, so typically there will be erasures of data within a day or some set period of time in SOC 2 compliance.
Somebody just asked, questions are great. Regardless of the fact that you've got all of these levels, and Gabe over here is nodding, because he understands what all these initials mean. But do I have to tell my client that I'm using ClearBrief and I'm putting their data up into the cloud or wherever this stuff goes?
Yeah, so our customers thus far have mostly taken the position, my understanding is that, the representation allows them to use technology that benefits the client, and just like they are storing things in their case management system, that's storing their customers' data. Do they ask their permission to store it in the case management system? Do they ask their permission to put their details of their case into a Westlaw search bar? It's a question, every firm can answer for themselves. There's nothing wrong with getting that, but actually, clients, what I'm hearing more is that they're demanding that they start using it. So for example, ClearBrief is used by in-house legal departments at the largest corporations. I can't name them just quite yet, but they're using it for that in-house use case I mentioned around internal investigations. They want that quick timeline of what happened. And now they are starting to ask and demand their outside counsel send them the ClearBrief version of the briefs. And they want to be able to look at the sources. They don't have Westlaw, they don't have Lexis, they don't know how to do legal research. Usually, when you're a GC, that's years behind you. So it's nice to have at your fingertips that evidence, though, so when your client asks you about the case, you can pull it up. So if anything, I think the trend is going to be more, and there was an article that came out a couple days ago too, saying, or was it CleoCon? Their research showed that clients are asking about AI even more than the lawyers are.
Thank you very much, Jackie.
Thank you so much.
Our third speaker is Gabe Tenenbaum, and he has been described as, if you Google him, the most tech-savvy law professor in the United States. And he's from Suffolk up in Boston, and his dean is going to give our luncheon speech. And with all due respect to the members of the first panel, somebody described Arizona as the most tech-savvy law school. I think Suffolk is the place, let me tell you. And this is the guy, because when we were all, hiring young lawyers to do document review, they were talking about how to do these predictive search queries and uploading database and teaching first-year lawyers how to use technology. So these folks, they're not ahead of the curve, they wrote the curve. So, Gabe.
Mark, thank you. My name is Gabe Tenenbaum. I teach at Suffolk Law, as Mark said. First, thank you, Mark. Thank you, Ernie. Thank you, Ryan and Jackie. Thank you to the Connecticut Bar Foundation, and most of all, thank you to all of you. I make it my job to get law students ready for a future of the delivery of legal services that I think and expect will look very different than the present. And by extension, in the next 9.5 minutes, I want to help nudge you off the dime if you're not quite there yet. So there'll only be one brief call and response period, but I need your help here. Who here are the avid AI users? Who uses AI avidly? If you're willing and able, leave your hands up. Who uses a Siri or Alexa at home? Who listens to music on Spotify or watches Netflix? Who buys on Amazon? Who got here using Google Maps? Who does a Google search? All right. Congratulations, you are all avid AI users. We are like fish swimming in water that we can't perceive around us. The technologies that have become everyday, like paper and pens, things that hundreds or thousands of years ago would have been a big deal, are now everyday items. So the question is, how can we as legal professionals move towards actively using them as part of our law practice? So I'm going to first make a negative case for why you must do it. The most basic rule of professional competence. This was fun. I don't do a lot of lawyering nowadays. I got to do legal research. In Connecticut, the most basic rule of professional responsibility for an attorney is competence. A lawyer shall provide competent representation to a client. Competent representation requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for that representation. Rule 1.1, and it's 1.1 for a reason. Now, there's a new interpretation of that. Came along about 10 years ago at lunch. You're going to hear from my dean, friend, and colleague, Dean Perlman, who was part of the group that wrote that very rule. Rule 1.1 means, in part, that to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. You gotta do it. It's not an option. That's the negative case. Now let me give you the positive case. Jackie made a reference to CleoCon, that's like Burning Man for legal tech nerds. It happened just the other day. At the opening keynote, Jack Newton, who is the CEO of the company, a brilliant person, made the point that for every lawyer in America, every licensed attorney, there are 55 Americans with a cognizable legal problem that didn't get it solved last year. We have a crying need for this. Connecticut Bar Foundation promotes access to justice. Roughly 90% of people that go into civil court do so without an attorney. And for those of you who are thinking, well, I do my pro bono, but I'm trying to make a living, the latent legal market, those people that need legal support, but it's not convenient or it's not affordable to them, although they could afford something, has been estimated to be in the tens of billions of dollars every year. That's money that you could and should have. Those are people that you can and should help. So part of the premise that we work with students is that we can actually use technology, including artificial intelligence, to help address some of those challenges. Now, if you feel like you're a little bit left behind here, that's okay. We're here for a reason, right? For those of you who are travel buffs or architecture buffs, perhaps you've been to the Supreme Court. On the frieze of the Supreme Court, at the very corners of it are two images, one of a tortoise and the other a hare. Built into the physical architecture of our highest court is this idea that we should go slow when it comes to change. We all remember who the hero was of that story. So how do we meet these standards for our organizations with respect to using appropriate technologies to help more people and to help them more effectively? When Ryan was speaking, I made the comment that his group, the Connecticut Law Firm, has done great work in terms of people, processes, and tools. And this is the level set. This is where you have to start. Before you buy the cool tools like Jackie's, which you should buy, you have to start out by asking yourself about the people. Do you have people that are aware of the technologies, that are keeping up, that are open to them, that will teach senior colleagues that might not be amenable to learning about it on their own, that will fly the flag for the firm? If you don't have them, surround yourself with them. Next, the processes. You know, 100 years ago, give or take, a revolution happened in manufacturing. It was the assembly line. And with that came the study of processes, the idea that you could do things better, you could do them more efficiently, and you could do them with less errors if you made a science of it. So, starting with Taylorism and bringing ourselves 100 years later to today, if we ask ourselves the question, right, are we using the right processes at our law firm or legal organization? Can we make a change? Can we gather data about that change and iterate and make it even better for the next time, less error-free? We can make ourselves better as legal operators. And finally, the tools. Of course, that's in the title of today's talk. Generative AI is in the headline. I had to turn off my Google News alert because I was getting 37,000 updates a day with stories about ChatGPT and generative AI. But the reality is that once you have the right people and once you have the processes in place, now it's time to implement the tools. So how do you do that? You feel like you're ready. What kind of tools do you implement? So I'm going to share with you a few categories of things that I invite you to think about, because the answer, of course, is it depends. I don't know what you do for work, and it depends on who you are and what your firm does and what your clients' needs are and what goals you're trying to serve. I also want to be cognizant of the Gartner hype cycle. I hope people know something about this, but when a new technology comes along, there's a predictable way that society responds to it. First, there's a technology trigger. People learn about something cool. And then there's something, and then you graph it. The graph goes way up, called the peak of inflated expectations, right? And following that, it goes way, 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 way down on the axis to the trough of disillusionment. And finally, to the plateau of productivity. And this, when there's a new technology in society, is a very, very predictable set of operations. We get excited, then we get really disappointed, and then we say, oh, here's actually how to use this thing. So let me go through some of the categories that I'd encourage you to think about as legal practitioners. First, document assembly tools. The recently departed, unfortunately, Michael Mills, who is the CEO of Neota Logic, a brilliant person, wrote a wonderful article about the different branches of artificial intelligence. Most of what we talk about today is one specific branch of machine learning and large language models, but the reality is that there are a number of other branches that are very, very useful to solve real, live legal problems. One is document assembly tools. People have heard of LegalZoom. It's a multi-billion-dollar company. This is the fundamental technology that underlies what they do. People go on the site, they answer a number of questions to figure out if they can do a bill of sale or do a simple divorce. The variables are coded into a document. The document is provided to them with instructions on what to do next. It doesn't just have to be something that's implemented for profit. My own colleagues at Suffolk Law, and I suspect you'll hear something about it at lunch, during the height of the pandemic, built similar systems for people who couldn't get access to justice through the courts because they were physically closed. And over 2 years, had over 38,000 forms for things like CDC eviction moratorium, lockout evictions, child in need of supervision and domestic abuse prevention. All those documents filled out using these document assembly AI systems and filed in court. I've joked with people, although it's only halfway a joke, that if our group at Suffolk Law School that works on this was considered a private law firm, we would be the single most successful law firm in the United States. But it also has interesting productization opportunities. One of our alumni, Julia Rogers, was recently on the TV show Shark Tank, where she launched a tool called Hello Prenup. Hello Prenup allows people for a few $100s to make their own prenuptial agreement. It might cost 10 times that and take significantly longer with a flesh and blood lawyer. And she got funded on Shark Tank, and she has a successful company helping people through the use of document assembly tools to get solutions to their problems. There are also other tools that it's valuable to implement. Electronic discovery has certainly hit the productivity plateau when it comes to the Gartner hype cycle. The ability to read 1,000 pages of documents where it would take a human one and have less errors is a real option now. Predictive analytics. You know, when I was a practicing lawyer, I read the verdict and settlement reporter every week, and I used that as an argument in a demand letter to say, this is why my case is worth what I claimed for it to be, because there were little squibs that had been written about other similar cases. The reality is now that that verdict and settlement reporter has been built in to a predictive machine where you can just enter the variables and it will estimate the range of the case. Legal research has revolutionized itself. Both Westlaw and Lexis do remarkable things. Professor Eskridge before made a reference to CaseText, which is a remarkable company built on top of GPT-4, doing truly interesting things. And finally, drafting-related tools. Everyone should experiment with drafting-related tools when it comes to artificial intelligence. Not just tools like Jackie's and Clearbrief, which I would say if she was not on the lectern, but simple, basic $20 a month ChatGPT. The ability to summarize information, recognizing the needs around cybersecurity and privacy, the ability to write a non-technical email, the idea to do things like draft notices and other documents that don't have client confidential information. We're there. Technologically, we're there. You can do that and it'll work more efficiently. So how powerful are these tools collectively? Well, the reality is that Goldman Sachs estimates that about 2/3 of the tasks that lawyers do will be replaced by these tools. That's their estimate, all the money. Goldman Sachs is in the business of making money and they're good at it. They say 2/3 of the tasks are going away. Of course, there's a saying by William Gibson, the future is already here, it's just not evenly distributed. It may be that for some of you, you can skate for several years without having that impact, but it's coming. So in closing, I want to suggest that people think meaningfully about these tools. They get to experimenting with them and they ask themselves the question, both for themselves and for their organization. Am I a person that can create a framework so I can figure out what's going to work for us? Do I have processes in place to make these sorts of tools successful? And have I experimented with implementing the appropriate tools? So thank you.
So Gay, you've got a lawyer over here who nearly 50 years ago argued with his partner as to whether we should buy a fax machine. And I said no, because it was going to depersonalize and speed up the practice of law. And this is an honest admission here. I was always a day late and $1 short getting my work out, so I complained it's in the mail. And the fax machine got rid of that thing, and we bought it, and we never looked back. So I assume, from what everybody is saying, that there's a minimum level of confidence. I'm glad there's so much white hair here. It's clear I'm yesterday's news. But if I was still practicing law, what is the minimum level of competence and what are the minimum tools that I should be trying to figure out how to manipulate?
All right, this is for the judges in the House. I'm gonna go directly to the rule that you have to stay abreast of the changes in the law and its practice, including the benefits and risks associated with relevant technology. So, if you are doing heavy discovery work, I think it behooves you to learn something about electronic discovery tools. If you're doing a lot of drafting work, I think it behooves you to learn about tools like ClearBreed. And recognizing that you're going to have to experiment, and the idea is that you have to stay up on these things and make appropriate decisions with your clients about what they want to implement. Incidentally, there may be clients that say, I don't care if I pay more. I don't care if there are more errors. You've given me this advice. I want to do it the old school way. Up to them, right? Just like if you were to go to your physician, right? The expectation is when you go to your physician, they are up on the current technology. And they might ultimately recommend one procedure over another, or one pharmaceutical over another, or one course of action over another. It's your choice, right? It's your choice as the patient. The same thing is true with a lawyer. I'll say one other thing, then I'll shut up, I promise. There's a saying I love that it's hard to tell people making $1 million a year they're doing their job wrong. And I hope that has always been true, and then some for you and for all of you in the room. But it's a funny conversation to have because it tends to be successful lawyers who come to events like this. It tends to be law firm leaders who come to events like this and say, I'm doing okay, right? I'm doing okay. And the argument I want to make is, not just are you obligated under the rules to do this, but this is something that you should affirmatively want to do because you can help more, you can make more money, and you can build a better firm and build a better society.
So when I first started teaching law school, the first semester, first year research and writing course, we made students use the books for the first half. And then we, eventually, every year that deadline got moved up, and eventually they started using the computer, and nobody shepherdizes cases anymore. But the question is, from the audience is, where do we stop teaching substantive law and just start teaching how to use computers?
My part of this, I want to end with this. I had a call this week with some legal technologists, and this is the present. This is not some far off future. And they said, Ryan, you know what? You should start an immigration firm. I said, I don't know anything about immigration. I don't know the first thing. And they start showing me their product. And Mark, I don't. The ease of which you're going to be able to do this and use this where you work is going to be profound and incredible and is not going to require a huge learning curve at all. And so I want to explain what it is I saw. This was technology that could translate documents out of 180 languages. So if you had a birth certificate in Polish, it could take it and extract the relevant information from a birth certificate in Polish in 180 other languages. It then can send information, or you can send information to a client in their language that says, we need this, this, and this. They upload those documents, it puts them in the relevant immigration forms for you. You don't do anything. It just puts them in the relevant information, relevant fields, creates the documents that can then be filed by the law firm. That is today, that is right now, that is going to come to every segment of law, every segment of legal, Mark, I think the ease of this is like what Gabe said, you're using AI right now, and this, for those out there, what I see, what I hear, what I preach is, like, this is real change, and if you're not embracing it, it's going to happen faster than you want it to. We're not talking 10 years from now, we're talking 1, 2, 3.
When I first started working for the judicial branch, we didn't have Lexis or Westlaw, and that wasn't that long ago. And a judge in the audience says, it's gotten better, but they still are resource poor. So the question is, how much of this stuff is open source so that judges can kind of get enough of it to start implementing it in the judicial system?
I can answer at least part of that. So when I referenced our work at what's called the LIT Lab, Legal Innovation and Technology Lab, to build guided interview tools, we use open source tools. And more than that, for the true techies out there, the code is listed on GitHub. So we've built tools on top of the open source tools that other people can take, make their own, and build up on in different directions. There isn't enough in the space of open source. Legal research is a particular problem because of the shepherdization problem, because of the secondary resource problem. But in terms of primary law, there are primary law research engines that are perfectly good. It's just that ability to shepherdize is sort of the missing piece still.
That's where the
Oh, go ahead.
this is where the magic is happening, and it's sort of last mile delivery sources. Because yes, Google, Microsoft, ChatGPT, Amazon, all these players are out there, and what's happening is the smart legal tech companies and well-funded ones like Thomson Reuters are pushing it over the last mile with relevant prompts to help do it, and you're going to see an acceleration in that space.
Yeah, and just speaking with, like, we already work with, like I said, judges, courts. I talk with judges probably like every week, and their clerks. It is already here, but I think that keeping in mind not all, legal information is created equal, and it is important for judges and clerks to be able to trust the source information. So one of the things that we've done in our platform, for example, is we always show at the top where that case came from, and we're going to be announcing another partnership soon with we currently partner with Fastcase, which has a wonderful commitment to make the law accessible to all, but we're going to be also announcing other partnerships shortly. But another thing I wanted to mention here is that you should be concerned if everything is free, because it is costly to, securely store data and to, run a good operation. So I think that it is important that courts, and right now, because like I said, we're working with courts, and what we're doing with them is helping them frame the cost. So for example, if they can use a tech tool to handle, their docket more efficiently, that is a real meaningful, savings that they can achieve. And so they can go to the legislature and explain, hey, we want to spend this amount of money for this technology, and it's ultimately going to amount to this amount of return on investment for the jurisdiction. So I think we shouldn't be expecting, judges to use only free tools, or, we should pay. But, of course, most technology companies have special rates that they make available to the judiciary and also to nonprofits.
So we had a Zoom planning this, and I thought it was going to be, horrible. And I looked at my watch, and it was like an hour and a half, and I hadn't even started talking. And we could go on forever, but I'm warned that our time is up. So thank you very much.
My name is Emily Jean Pinto. I have the pleasure of moderating the third panel today. I am joined by Joe Carvalho and Anna Gressel. They are going to introduce themselves briefly. Our panel, we will talk a bit about things specific to lawyers and law firms, but this is also going to have a little bit of a broader focus, talking about implications, more for probably some of your clients, particularly if you're representing companies or if you're in-house, and building off of some of what we've already learned from the other two panels this morning, talking a little bit more about things like compliance. This does apply to everyone in a law firm if you're looking at implementing the tools, and talking a little bit broader about some of the moral and ethical issues surrounding AI. So we're going to start with Joe. The way we've divided this up is that Joe and Anna will each talk for about 10 to 15 minutes, and then I have kind of a prepared set of topics to talk about, but please text me your questions. We'll build off of them. It seems to me that...
Hi, well, thank you, Emily. I was here for the first time at a holiday luncheon, I guess, or dinner. And the year was 1969, if you can believe it. And interestingly enough, I was with a group of people, I think there were 6 or 7 of us, that were engaged in an artificial intelligence project to identify the 5 major white blood cell types. We were working for PerkinElmer Research. We had imported a whole bunch of people from Bell Labs that really became part of that research department. And you may know PerkinElmer through the Hubble telescope, for instance, and Celera and genomics projects and so forth. So it's a pretty leading company, but a very low-key kind of company. And so, in some ways, we succeeded. And much of what we were developing in that era, which was about almost a half a dozen years for myself, we developed techniques which are still in play today. And we think of GPT as being, or GT, Generative Trained Transformer, generative, we'll get it. But at any rate, as a revolutionary technology, but in fact, AI is sort of a core technology. And by core, what I mean is this: we run across these cores through the course of civilization. The wheel is a core technology, and it lasts for thousands of years. And it infiltrates just about every part of our lives. Drive a car, we have a steering wheel. Right? There are other core technologies, the combustion engine, for instance. Right? And we appreciate that, again, the combustion engine has found its way into every corner of our life. We all drive cars. Interesting thing about core technology is it's persistent. It's there, right? And the very essence of it doesn't really change. So even though we may see other uses for that technology, the actual thing exists at the time of its inception. And it obviously morphs and has other adjuncts that may accompany it to make it have greater utility. And so here we are, and I'm looking now from that perspective, 1969 to the current, 2023, and I'm looking at, here's this core technology which was there and is here, and there's a lot of things that one can imagine if they think about this lens that we look through, this lens of time, and how it is that core technology got to where it is, and also how it is that we as humans and as those that use this technology have an inability to foresee the future and how it's going to play out. So that in 1969, when we were working on AI, for instance, it was hard to see how it was going to play out, even within the framework of a couple of years, let alone the framework of 50 years. And so we sit in this room today and we're talking about this technology and all the things that it can do for us now at the very present time. And that's good, right? Because I recommend we dive into it, we get used to it, we learn how to drive this new vehicle, right, for purposes of good, for good reason, right? For our own benefit and for the benefit of our clients. But the question I have, and I'll just leave with you because I don't have the answer, right, is just what is it, okay, that we can anticipate is going to happen next year and the year after that. In the case of this blood work, this blood technology that we were developing and we succeeded at doing, right, identifying the 5 major white blood cell types, in 2 years' time, we had converted that piece of technology into a system which could be installed in an airplane that could look to see and distinguish people on a boat, okay, from the water that they were traversing and the shore that they were going to. And that system was the kind of system that was becoming important, I should say, to the government, to the Defense Department, because during Vietnam, okay, they were doing surveillance and they were looking to see if they can identify people on the river. Right? So here we went from something that was very good, right, the identification of 5 white blood cell types, to something which, in my own estimation, really wasn't all that good. Okay? It was for an ulterior purpose, okay, that really we hadn't started out by looking, right, to apply to. So I mentioned that just by way of perspective, okay, that we should all think through just what it is that this new technology is going to be utilized for, because it all has dual use. Not the least of which, incidentally, is the combustion engine, which in 1900, when people started driving cars, whoever thought it was going to take down the planet? All right? You had no way of anticipating that, but that's what happened. So something that was very good, right, and it still is good, has consequences. So I want to bring that to bear as we get into this thing. How much of this is science fiction, right? And this is one of my favorite authors, Ray Bradbury. Any idea that occurs in the head and doesn't exist yet, but soon will, and will change everything for everybody. And nothing will ever be the same again. Right? And as you have an idea that changes some small part of the world, you are writing science fiction. It's always the art of the possible, never the impossible. If I lived in the late 1800s, I might have written a story predicting that strange vehicles would soon move across the landscape of the U.S. and would kill 2 million people in a period of 70 years. Science fiction is not just the art of the possible, but of the obvious. Once the automobile appeared, you could have predicted that it would have destroyed as many people as it did. So let's keep that in mind, okay, as we get excited, okay, over ChatGPT. But there's that other side of it, and we haven't talked too much about it, as to how it's going to move the the creativity, okay, that exists among a good segment of our population that basically earns a living doing that, for instance, and how it's going to displace them. So it's not all good that we can craft questions for depositions or the like, or do legal research and the like, or craft better arguments or essays. But there's a whole other piece of this thing, okay, that needs to be considered. And as lawyers, I think we need to consider this, because as we're going to talk about in a few minutes, there's these significant troublesome questions as to whether or not such things as GPT actually infringes on copyright or infringes on other people's creative juices and talents and investments. So those are real things that we can't ignore in the conversation we're having today. So the fact is that AI has not suddenly descended upon the world, okay, or the legal profession. It's been here and it's been going on. And there's a lot out there even today, okay, that has been going on, let's say for the last 20 years or 25 years, that we as lawyers are hardly aware of. Back in the early 2000s, I worked for the Hartford Fire Insurance Company. I was their first IP lawyer, first patent lawyer for the company. And they were interested in business methods because they saw what Amazon was doing. Amazon was decimating the commercial establishment as we knew it, at least as I knew it as a kid. Corner stores have long since gone. Okay? But now we're sort of ravishing a different segment of society. All right, with business methods like Amazon. Bookstores, a good example, right? The selling of books completely changed. Right? So I was there, and we had concocted or conceived of or invented different processes, as I think Gabe spoke to, that would facilitate actualization, actuarial analyses, for instance, or facilitate claims processing, or facilitate policy premiums, for instance. And so, for instance, one of the things that we had come up with is an invention now, okay, where they would put sensors, right? This is the invention. They put sensors on buildings, and sensors in cars, and sensors in other places, so that we could determine whether or not that particular building was the subject, in that case, of, let's say, earthquake vibrations, or vibrations due to fracking, right, around in the Midwest, so that they could get these things reported back, right? And then therefore set the premiums, or somehow predict, okay, when these buildings were going to crack, I guess, and crumble. So there were those kinds of things. What we don't know as lawyers, and this has been around for 20 years, but I'm assuming, maybe some of you folks do, and I shouldn't make an all-encompassing assumption here. is that there are products out there of which we know not. So for instance, in looking at actuarial tables, or looking at premium setting, or looking at claims adjustments and the like, how much do we really know about the AI that is running those systems? How much do we really know whether those AI systems have within themselves some forms of inherent bias? Some other things, okay, that may well come about, okay, in the sense that it may disadvantage, right? You know, people of lower income, for instance. And what we're seeing, and we're going to talk about this later, I think Anna's going to talk about this, is that in the European mode, okay, where they have done some legislation, they're initiating legislation on AI, they're looking at some of this stuff in the general sense, say that, you know, if you're involved in a business which is, let's say, or an AI product that has some influence over such things as academic admission to institutions, or it has some some involvement with loans, with giving credit, for instance, and there are other things like medical, or maybe things having to do with weapons. These are in a special class or category. And then there's a lesser class, and those categories may well require licensing. They will require licensing. They'll require at least the kind of inspection that the Federal Drug Administration now is requiring of medical devices, all right, that incorporate AI, for example. So we'll talk a little bit about that, I think, in a little bit. And then there's a lesser group, okay, that are more like Facebook and other things such as that don't have those significant deleterious effects, but still may well have other social effects. So there's another category. So they categorize and classify these things. As lawyers, of course, we're going to be interested in understanding better, okay, what the intricacies and what are the types of products, and just how is it that AI is there influencing how it is that people's rights, duties, and obligations play out. So the fact is that it's impossible to predict the next AI milestone. Just talked about that. And then we should be discussing what issues to consider in evaluating the benefits of an AI-driven system today, focusing on the legal, ethical issues that can arise, which is what Emily, I think, made a point. So we make critical decisions that have legally significant impacts on our clients' interests, and the delivery of AI legal services that rely on computer-generated content requires added due diligence to ensure the information and the insights created are accurate and appropriate. I think there's been already a lot of discussion on that. I won't take too much time on this. But technologies, predicting the future, as I said before, is difficult. But take this into consideration, and especially with respect to GPT. It's the rate of diffusion that's gotten us here today in this room. All right? In other words, this is one of those things that's moving exponentially to sort of almost like a wave, like a tsunami. All right? It's engulfing. I think Wendell said there was 100 million people, I guess, using this thing already. It's only been around, hasn't been around a year. So it's really attractive. So the rate of diffusion through society is going to, has to obviously impact us. The strike in Hollywood that the writers were having was over this. All right, that was a big part of it. All right, so it's affecting, you know, employment, labor relations. Multiple products, GPT is anticipated to augment the dual use. And I'm particularly concerned about dual use because as an engineer for 20 years before I started practicing law, I saw how dual use, became an important ingredient in just about everything we did. So that a scanner that I worked on with for the lunar orbiter, that was going around the moon looking to take pictures as to where the first spaceship would land, was a tracking system that was then used in the cruise missiles. All right, 10 years later. Right? So there's another example of dual use. Now the question is for lawyers, if you really want to sort of get your thinking hats on, you want to exercise your imagination. What's the dual use for GPT? Right? Those are the things that sort of should keep me awake. The depths to which it may penetrate daily life, including the countless fields of employment. So let me sort of jump ahead and cover one last thing, and then I think I'll be done, right? AI is not interested in security. Let me just jump ahead on this thing, right? It's vulnerable to the same hacks and attacks, okay, in computing systems. The unexpected variations can render them ineffective. And so think about this slide when you begin to think about absorbing and taking in some of this new technology, and GPT in particular. You know, your client's data, if you're going to be using GPT, and we did talk about that, will be out there on the internet, will be used, so we've got to be careful. Also, you are not, it is not your supervisor. Okay? You are in control. So everything that you do should be obviously reviewed by you as if there was an associate working for you, or a legal assistant. And so let me leave it there, all right, and we'll get on with the next piece of this.
Thank you all. Thanks so much for having me here today. I'm Anna Gressel. I'm a counsel with Paul Weiss in New York, and I'm going to talk about this from a different angle than I think we've heard so far today, which is, why does it matter how your clients are using AI, and are they using AI? And the short answer is yes. They are almost all using AI right now. All of your clients across industries, we see this in every single industry right now. There's a massive amount of pressure to adopt AI if they have not already been doing so for many, many, many years. And that's what our practice focuses on, is advising companies across industries on how they're developing and deploying AI in different kinds of ways for different kinds of purposes. And I've been doing that for about 5 years. So it's been, quite some time, including into this period of time with generative AI. What does that look like in practice? And just to give you a bit of background, we do everything from helping advise on particular deployments of AI tools, so risks around specific kinds of models or systems and products, but we also help companies set up compliance and governance frameworks to help actually scale that across their enterprise, make sure that they have their arms around these questions that people have been asking today. How do you even know which tools are being used in your company? That's a big challenge, and so we help them with that. We also help with regulatory defense and litigation. So it's a pretty broad practice, but it gives us a lot of insight into how companies are using these tools in a bunch of different sectors, including, I think for us, tech companies, financial services like banks and insurers, private equity, pharmaceuticals, other industries. And I'll just say, I think there's really nothing like what we've seen today in terms of the adoption pressure that is happening within companies right now. Almost everyone who comes to us says, our business is really invested in this. They're really curious about what the technologies can do. And even if we've been using AI, the pressure is on to get those use cases out. And I think we're really in a moment when people are trying to harness the capabilities of these technologies to both make themselves more efficient, but also make themselves more competitive. And it's that competitive edge that I think is really interesting right now. We're seeing companies really begin to think of this as a competitive value add and get worried about being left behind if they're not at the forefront of technology adoption. And why is that? Well, some of this at least has to do with ChatGPT and generative AI, which I think many of you know. We've talked about some of these differences, but many of you know came out in around December of 2022. So we're going to round out the year pretty soon, 1 year of major commercial deployment of generative AI technologies. There were some out there before then, so I'll admit to that. But why does that matter, at least from a legal perspective? Well, sometimes I like to talk to people about now what I call the before times with AI, like what happened before generative AI, because generative AI has taken over this discussion. I think there are some important differences. The work that we did from a legal perspective, there are real similarities, but there are also differences with generative AI. And I just want to explain a little bit about why that's the case, because I think that can help you issue spot some of the things that your clients are really worried about today and what kinds of issues they're trying to grapple with it, to the extent that they're not already coming up for you, issues that might come up for you in your legal practice. So before generative AI took the world by storm, generally what we saw was companies developing very sophisticated analytics tools, but for very narrow purposes. And what do I mean by that? I generally would mean a tool that's used to crunch big data sets and come up with a defined prediction, recommendation, or ranking about how to treat a particular situation. So is this a fraudulent transaction or not on my credit card? That was a transaction that was generally powered by AI, using data to figure out if there was something anomalous, and then making a recommendation. Should it be rejected? And then have a text sent to you saying, hey, we rejected that transaction. Was that fraud? Those were the kinds of what I would call narrow AI tools. We also saw a bunch of narrow AI tools in the insurance sector. Can we accelerate this person's application for a life insurance policy because we can tell that it clearly meets criteria that we would generally think of as low risk, and so we can put them in kind of a low risk pipeline to accelerate. And we also saw big data sets used to rank, for example, the feeds that you see on social media. How you see feeds and how you see ads on those feeds are generally AI generated and ranked. And so that's like the prior world of AI. But those tended to be tools that were deployed by specialist groups within companies who were deep experts in what they were doing, and the tools had metrics to define what was successful and what was not. Even if they could be used for dual uses, generally companies knew what they were used for and how they were being deployed. When generative AI came along, that changed in a significant number of ways, including because those tools were now just apps on a phone, and any employee could pick them up and use them. And so I have ChatGPT on my phone. I can use it for whatever I want unless someone tells me not to. And that was true for every employee in every company almost immediately. And that created a number of governance and compliance challenges for companies. Should they tell people to turn off their access to ChatGPT? Should they ban it? Should they ban any link to any generative AI? Companies suddenly started to have to think about the risks of every employee, sophisticated or very unsophisticated, using AI. And not just using AI for these defined tasks, but using AI for anything. Putting company data in there, putting code in there, putting sensitive company documents in and asking, what should I do about this? Or typing, should we invest, this is the company I'm at, should we invest in this kind of investment? And as some people have mentioned, that data, unless you're using kind of more buttoned up types of tools, particularly the recent enterprise deployments we've seen, that data actually can go into training the model. It can be accessible to engineers at some of the vendors of these tools. And that data basically can become public. And so for companies, that was a huge risk. And there was a real, I think, effort to get their arms around how AI was being used, just not only in these traditional areas, but in the generative AI tool space, and figure out, okay, as companies, how do we want to manage that risk? How do we want to mitigate that risk? So I would say, from a legal practice perspective, that's been the conversation we've been having, among others, the conversation we've been having recently, and regulators are getting concerned about how these tools might be creating risk. Gary Gensler is concerned about the ability for generative AI and other AI tools to cause, what he calls model similarity, cause the markets to move in similar kinds of ways. There are real issues around what the antitrust regulators might call algorithmic collusion or pricing that moves together. We've seen the Department of Justice, HUD, the EEOC, the CFPB, the federal banking regulators get very concerned about bias in AI. I mean, they had always been concerned, but generative AI creates even more of a black box in some of these systems than what had previously been the case, and they're more difficult to govern. The federal regulators and state regulators are concerned about that, and they're beginning to ask questions. So from a company perspective, it's also incredibly important to understand how tools are being used and whether the use is consistent with laws and regulations and whether they're defensible in light of those laws and regulations. I think we'll turn it back soon, but I just want to talk a little bit just in terms of the issue spotting of the kinds of legal issues that tend to come up in our practice when we're advising clients on how to think about deploying these tools and when we're advising on particular models. The first is risks around what actually goes into the model. So if you're putting in a prompt, or any one of your clients' employees are putting in prompts into the model, there are a number of different risks that come up with the prompting process. The first is confidentiality, as I mentioned before. It's unless you're using very buttoned-up versions of models and some kind of segregated environments, there are risks that material non-public information might be put in, trade secrets, PII, and that other people might be able to see those, even privileged information. That question comes up a lot too. Information that might then be stored as value or protection to the company. So that is something that we are really, I would say that's usually the number one question that comes to us from clients. And that is something that we're seeing vendors begin to solve for by creating and architecting these tools in a way that is more fit for purpose for enterprise clients. And by the same token, we're also seeing a fair number of clients try to or endeavor to ban the use of like off-the-shelf ChatGPT apps on their phone, which have none of those protections. We're also seeing really interesting questions come up about whether companies have the contractual right to put data into the model. So for example, some of these models can be tuned on particular data sets. So in the pharmaceutical industry or in the financial services industry, you might want the model to perform better on certain types of data, financial data, policyholder data, for example. And whether you have, whether a company has the right to put that data into a kind of a tuning data set may very well depend on a very close read of the grant of rights and the license to that data or that information. And so the contractual rights around that I think are really important. We're also seeing some companies, by the same token, asked to audit the data used by their counterparties to train AI models. There's risks around the code being fed into the model, which I think Joe mentioned. Are you feeding, if you have people coding and using ChatGPT or any of these other tools to code, is there a chance that they might accidentally introduce malicious code into your code base? That's certainly a question that comes up. Privacy risks with sensitive personal data that's being introduced into the code. So that's on the, I would say in general, on the input side, those are questions we see. On the output side, we see questions around whether the models are accurate enough to be used and used offensively, whether or not they're compliant with all kinds of different laws and regulations, including laws and regulations that might, for example, require an explanation to be given to a consumer about how they're being affected by a model, for example, under ECOA or similar regulations. That's a particular issue, you know, in areas that implicate the civil rights laws, for example, or consumer protection laws. We see questions about bias risks. Is there going to be an unfair bias from these models? Is it legally actionable? Why or why not? And risks just more basic, I would say, ethical or transparency risks. Do companies need to disclose the use of AI to customers? That came up with the legal technology question earlier, but it comes up in other industries too, when there may be an obligation to disclose that a particular customer or consumer is interacting with a model. Do your regulators need to know, or your investors need to know that you're actually using AI in certain kinds of functions? And have you made statements that might be considered to be misleading or have omissions about the use of AI? And finally, I just put one final kind of risk bucket in there. Or I guess two final buckets. The first, the second to last, which I think is an important one, but I think affects a tranche of companies more significantly than others, is of course the risk of IP violations. There are big suits right now about the data that's used to train these models, much of which is scraped off the internet, and there are some major suits going on between content providers on the one hand, who say you didn't actually obtain rights to train your model using our data, and the tech companies on the other. So that's one other area that I think is very significant. But the final that I'll just mention is operational risk. On a very, very basic level, if you're using AI in critical functions for a company, do you have a backup plan? If that AI doesn't work as intended, it needs to be taken offline. That's something that I think can be often overlooked because of all of the downstream implications of having to take something offline or somehow put a pause on it. But at the same time, AI can act unpredictably, and so it's a predictable risk that AI might be unpredictable. And it's one that's worth solving for. All right, I'll leave it there and we can keep.
All right, plenty of fodder for continued discussion. One of the questions that came in while Anna was talking, actually, I think it was great to how you ended that talk when you were talking about some of the risks.
There are a couple of questions asking if you could talk a little more specifically about the risks that accompany adopting AI tools. So I think, why don't we start with, kind of, I guess, a client comes to you, big company, one department in the company wants to implement a tool. How do you advise, for example, in-house counsel on what they should be considering, what are the big picture issues, and the kind of further implications you touched on, like governance, how do those relate together? So I think this also goes to any of the law firm owners here, your business owners, right? And anyone who is in in-house counsel or anyone who's at a government agency that's looking at this and you're the in-house counsel to the agency, I got to assume it's mostly the same considerations, just in a different industry, right?
Yeah, I think that's right. I think there are a number of similar concerns in both cases, and the same kinds of frameworks apply. But these questions tend to come up to us in two forms. One is, oh my gosh, I can't believe this. I just found out that our company is doing X. Do we have a problem? And that is, I would say that's a pretty frequent question, particularly again, in this age of generative AI, where people may just be doing whatever they want to do with the tools available to them. So often that conversation starts with an assessment of the risk of a particular model, but often then it leads to this broader conversation about what governance structures are in place within a company and whether those are sufficient to surface the risks to legal at the right time and in the right way. Usually when those kinds of more panic conversations come to us, it's because there has not necessarily been communication across the company about how AI should be used and about how use cases should be approved. And so there's, I think, a big process piece to all of this, which is, I don't know if we have in-house folks in the room, but just in terms of making sure that everyone knows what the right system is internally within a company for escalating, for getting a use case approved, but also for escalating potential risks within a model or within a particular and this is a conversation I'll just hit on this one point for a moment. When we talk to regulators about AI who are concerned about the way it's being used, one of the conversations we do often have is around that governance. And we're seeing regulators become much more prescriptive and much more vocal about the kinds of governance structures they expect to see from particularly regulated institutions around making sure that senior management and the board is involved in supervising the AI use of the company, not at the operational level, but making sure that the way that the company has calibrated its risk tolerance around AI is consistent with the risk tolerance set by the board, that the board has some insight into that conversation that's happening lower down within the organization. We do often hear regulators also ask, how do you know that you know about all AI being used at the company? And how would you know if something was going wrong? And those are pretty typical questions that we hear them voice concern about. And so the governance around this can help solve for a lot of those problems by just making sure that there is a way of escalating issues as they occur, but also a way of ensuring that the right kinds of technologies are being captured within the governance system in the first place.
Joe, do you have anything you want to add?
I want to raise the point that I think it's tangential to this, but I think it's worth making. What I see rolling out into the future, right, is that professions will develop their own GPTs. So the legal profession eventually will have their own GPT. It won't be based on the kind of input that the current OpenAI model is working with. They'll essentially take the corpus, of law as it exists in case law and in statutory law, and will incorporate it into such a device like a core, right, that is GPT. The same thing will apply to the pharmaceuticals, will apply to every industry across the board, financial industry. And the question will be, as lawyers, how is it that we penetrate those things when it becomes important for us to appreciate just exactly where their information is coming from, or whether biases exist within those systems. So I don't want to get too strung out in the future, but I do think that, again, by way of anticipating, You know, we talked earlier about fax machines, right, which I think was, you know, apropos. And who saw from the fax machine that we would eventually have a computer on our desk? And that was a period of about 10 years, from the fax machine to having a green screen. Right? And then we had the internet, okay, about 10 years later. These are the things that I think lawyers should at least begin to consider, because as someone said in the room, that it's a spectrum, and that maybe some of this stuff is right here, right, among us. It's already, at least a few of us already know this, right? Because that the future doesn't necessarily roll out like this suddenly emerges, as GPT has incidentally. But it sort of rolls in sort of in its own, on its own pace, and it may well be here. So when I'm thinking about litigation, for instance, I'm litigating cases all the time, the question is to anticipate, or to be creative, to be imaginative as to, you know, what might exist at that moment in time. Right? So, I think those are things that we need to at least, you know, get our brain on.
A couple questions have come in, because we're all lawyers, asking about what rules apply and what regulations apply. I think this is really for, I know both of you have comments to make on this, but can you kind of give everyone a summary maybe of where the regulatory framework is right now? And it seems Europe is most advanced, and then also talking about where the US is headed and what you're kind of seeing at the different levels of government as well.
Sure. We get this question a lot. I would say we tend to take it two ways. The first is that existing laws and regulations apply to AI, and regulators and enforcement authorities are very vocal about in that. And I think in particular in the US, where there isn't as much of a, I'd say, high likelihood that we have any kind of federal legislation passed on AI anytime soon. So there are many different existing laws and regulations in the U.S. that apply to AI, and it's, you know, it would be almost impossible to kind of get into all of them, but the ones that we tend to deal with on a pretty regular basis are, you know, financial sector laws and regulations, including regulations about how models are governed, for example, in the banking sector, or insurance laws and regulations around discrimination, for example, unfair discrimination, federal laws and regulations around unfair discrimination in various ways. We also do look at privacy laws very frequently, because to the extent that personal data is used to power AI, that tends to implicate privacy law, and there's a very large privacy community focused on the intersection between AI and privacy. Just, you know, putting, I would say, existing laws to the side, because there's almost no end to that conversation, there are efforts to create new laws and regulations that are AI specific, and I think it's worth just pausing on that for a moment and mentioning a few. In the insurance sector, we're seeing a lot of very interesting activity, and that, you know, some of that has come, a little bit of that has come from Connecticut. I would say Colorado is out in front the furthest. They have a governance regulation for the use of AI in life insurance underwriting, and also a testing regulation that focuses on how to test for discrimination. It's one of the most prescriptive, it's the testing regulations in draft form, but it's one of the most prescriptive testing regulations around AI and bias that we've seen anywhere, actually. And so we'll see how that pans out. There are a lot of comments on that. But, you know, there are also efforts to regulate AI in the hiring context. For example, New York City has a law that focuses on AI-based employment tools, and any tools used for hiring or promotion, not firing, but hiring and promotion within New York City are governed by this new regulation that went into effect over the summer that also requires testing for discrimination in that context. We're seeing a lot of activity in the hiring space generally around regulators providing guidance on AI. The CFPB has been very, very vocal in the consumer lending space and consumer product space, more financial product space more broadly. And then, of course, the EU is that's the main conversation that's happening, I think, in AI right now in terms of a cross-sectoral regulation on AI. And as Joe and I think maybe others have mentioned, the EU would take a risk-based approach and tier models based on the risk they pose, I think, to society more broadly. But they have an unacceptable risk tier that focuses, I think, on tools that don't tend to be often commercially deployed, to be honest. But they're worried about things like social scoring in China and the possibility of replicating like large-scale social scoring in the US, so they ban that. There's a lot of discussion about what should be considered high risk right now. The things that sometimes tend to go into that bucket are workplace tools, much more broadly than would be regulated in the US, for example. So even workplace surveillance would be considered high risk, whereas I think in the US that tends to be left a little less regulated. Credit, underwriting, some insurance tools, tools with an impact on health and safety, for example, critical infrastructure. But the big discussion right now is how to regulate foundation models, which is another word for these large generative AI models. And the EU is having a significant discussion right now about how exactly to do that. They may require, for example, disclosures, certain kinds of prescribed disclosures from vendors that are selling those tools, but also obligations for companies adopting them, because they're worried about the idea that if left unregulated, this entire new ecosystem of models will lead to kind of a gap in liability. And so they're really trying to allocate who should be responsible for those tools in a way that's comprehensive. So there's no shortage of interesting things. Canada, Brazil, Hong Kong, Singapore, many international jurisdictions are getting interested in AI regulation, and the approaches differ, but Europe, I would say, is pretty far out in the front, and China.
Yeah, I think there's probably around 60 countries or so around the world right now, putting out, or have put out, or are putting out AI type regulation. It's coming from maybe 3 or 4 different places, right? The first one is the governmental. Okay, so we have at the national level, which we have not in this country moved very far. We have some of our agencies which are farther ahead than our national government, like the FDA, for instance. Then you have the state ones, and I think the state ones are actually leading the national. Right? So in Connecticut, we're, I think, a leader in some of this. Right? So we have an act concerning artificial intelligence, automated decision-making, and personal data privacy. Okay, that looks like it was part of the January 2023 session, and some of these laws will go into effect next year. And what it's talking about, the bill requires the executive and judicial branches to conduct an inventory of all the systems that employ artificial intelligence, AI, and develop and set policies and procedures on developing, procuring, using, and assessing systems that use AI. It also requires them to publicly post the inventory and policies and procedures online. I think it's somewhat unrealistic personally, because as I was mentioning before, it's impossible to figure out just exactly where AI is, okay, in the system you're employing at any moment. But nonetheless, it's a great start. It prohibits the executive judicial branches from implementing any system that uses AI unless they have done an impact assessment to ensure the system will not result in any unlawful discrimination or disparate impact against specified individuals or groups. For example, age or race, establishes a 21-member commission to oversee this. So Connecticut is doing that. I've been in touch with somebody who's working with a couple of state senators in Hawaii. They're doing the same thing. We mentioned Colorado. There may be other states around the country. So I shouldn't say it starts there. It's there. The second level are the industry associations. So for instance, IEEE, which I'm a member, they must have a dozen, maybe more, right, sections, okay, around the world, which is kind of interesting, that are all dealing with this subject, right? And what they're doing is they're putting in codes of responsibility, codes of ethics. I suppose the ABA is doing the same thing. Right? So we then move from the regulatory based on governmental regulation into the association that regulates the profession itself. And then I would suggest, or I would say, and maybe Andy can speak to this, is that you have companies with themselves. So you might have an IBM, or you might have maybe a Facebook, I doubt X. might have within their organization, again, code of, be it responsibility or compliance. And then the question is whether they have compliance sessions for their employees so that everybody's brought up to speed. So we have these three different levels. And I say that for we lawyers, when we're out there trying to figure out where, who dropped the ball, it could be dropped at any one of these three levels. So.
Great. I had a couple questions about copyright and IP issues. One question I was particularly interested in, any comments you might have about, I think, and Anna alluded to this earlier, the class action going on by content providers against some of the tech companies. So this question was specifically about authors, and I believe Stephen King and John Grisham are involved in that lawsuit. And another question I was interested in issues surrounding, for example, AI in music and using certain artists' voices with other artists' melodies. Myself, I'm interested in kind of the deep fake and the way you can manipulate just a small sample of someone's voice. You can create a whole conversation. This could go in a couple of different ways, but people are particularly interested in your thoughts on that litigation and where that might be going.
Maybe Anna can comment more on the litigation, but just from a more general standpoint, I've been a musician most of my life. And so probably 20 years ago, I started using AI in the creation of music. So I played jazz piano and I needed a trio behind me, okay, so I bought Band in the Box. And it creates, my background, or what we call backing tracks. So backing tracks are a pretty common feature, okay, of musicians across the country. Everybody tends to use them. What's occurring here with ChatGPT is that they're becoming much more specific as to whom it is, okay, that they're utilizing for that backing track. And with music, unlike other forms of expression, copyright has a much more narrow focus. So you can use like 10 notes, okay, of something from John Lennon, and you're going to get sued for it, right? Where you can use a paragraph, okay, from John Grisham, right, and get away with it, because it has to do with fair use, and it has to do, obviously, there are other things that those of you that know something about copyright know, okay, in terms of what is your motivation? Is it commercial? Is it for education purposes? So in this instance here, where ChatGPT, okay, has admitted that it would take much to get OpenAI or Microsoft to talk about how they and who they and what it was, what databases they actually scoured. They're using the content, and I think ultimately it's going to depend on the extent to which they actually I want to use the word purloin, negative connotation, utilized any of the copyrighted material that they incorporated in their database.
I'll just add to that to say, specific litigations aside, I think they're really, really interesting issues, as Joe mentioned, raised by these cases, including how to define what is transformative in the purpose of in the context of a new technology deployment. I mean, we've seen a lot of different fair use cases bubble up, but only a few go up to the Supreme Court in recent years that would even kind of touch on how to think about this question, and certainly what the technologies are doing today has been different than what they were doing 6 months ago or a year ago. So when you think about the time it takes for these cases to get to a decision, to an appeal, to a subsequent appeal to the Supreme Court, I think it's going to be a while before we really are able to get the contours of how we even think about what the market is, how we even think about what is transformative from a fair use perspective. That's just my own personal opinion, not a comment on the litigations per se, but on the fact that sometimes I think these cases are litigated against the background of a very different historical landscape than when the technologies were first deployed. And so some of what we're looking at is not just where the technology is today, but where it might be going in the next year or 2 or 3, because it's just such a defining question in terms of how you even look at the fair use factors. It's like through a prism, I think, of the historical moment. And so these are, I think they're tremendously important cases. Everyone is, I think, super interested in this, and it may be the case that these questions also start looking different as more and more companies create their own, specific generative AI models rather than just licensing them from some big companies. We're going to see, I think, even a greater diversification in that landscape. So it's definitely an interesting place to watch, and we're also watching some of the cases in other jurisdictions. I think in the UK, there are cases around these issues coming up. So it's certainly fascinating. I think someone said earlier, there's no shortage of work for IP lawyers in this space, and that is certainly true these days.
But they've also, in other instances similar to this, for instance, IBM was obtaining 10,000 patents a year. So when the computer industry got into building desktops, they inevitably used IBM technology, IBM patent technology. IBM couldn't feasibly go after everybody. And so what they did was they simply licensed technology. So anybody that made a computer processor paid 5% or 2% to IBM. ASCAP did the same thing 40 years earlier with respect to music. Right? Everybody who had a cabaret license had to pay ASCAP a certain amount of money so that bands could play music in their establishment. Right? So the various industries have always looked for ways in which they could be compensated, right, by virtue of the entity or the thing, okay, that was infringing on their IP. And so I suspect in this case here, they may go in that direction, so that OpenAI actually pays John Grisham or somebody else who claims they can prove some scintilla of evidence that they're using their copyright material. And that may well be the way it's worked. There would be some kind of licensing arrangement, because the litigation doesn't really prove successful, and you're not going to stop OpenAI. Right? It's a thing. You're just not going to stop it. It's a fast-moving train.
We got a question in that basically saying that providing AI tools providing legal information may be fine, but where does it cross the line to having one of those tools giving legal advice? And is anyone looking at governing that now?
It's called the unauthorized practice of law.
I think that would be it.
I made a few points here. But let me just see. Which raises a question. So generative AI has the potential to increase the risk of unauthorized PL. It obviously can provide legal documents, right? But I think that's an old question that's really been, put aside. I mean, 20 years ago, maybe 25 years ago, it was a big deal about people providing legal documents in whether it's practice law. So I don't think that's going to be the issue. And I suppose anybody who wants to use GPT, right, in order to obtain legal advice, it's their call. Right? I mean, without a lawyer, of course. Right? The question is whether or not they commercialize that in any way. Then I think it's up to the practice, honestly. I mean, I think it's up to we lawyers, okay, to keep our eye on this stuff and report it when we see it. Now, is it possible for us to be the guardian of this issue? I don't know, but I suppose that's the place to start.
Yeah, I mean, I'll say, I'm far from a legal ethics expert, but it is just worth noting this is coming up in a lot of different fields where there's an obligation to effectively supervise technology. So I think this is a very interesting issue coming up in medicine right now, with effective supervision of, for example, clinical decision support tools or other tools that might be used in hospital settings or in diagnostics. We're generally seeing this question come up. How do you know whether a tool is effectively supervised, and how do you know whether someone has the skills and expertise to do that? And I think that's going to be a fundamental question, not just for the legal profession, but for legal training going forward. How do you know whether someone does this has a lot to do with how you decide how to teach it and the standards by which you test and uphold that kind of expertise. And so I think supervision of technology in my own opinion, is just going to become another part of how we define the legal profession. We define our own practice obligations, but I think that's going to be true across other kinds of professions in the same way that we know, I would hope, very much assume that pilots know how to use an autopilot, right? So it's, you know, it's part of this practical governance, and it's a recognition of the fact that humans always use technologies, but always have the obligation to use them in a way that aligns with responsible deployment, however that is defined by a particular profession or community.
Well, let me just add something. Wendell has been associated with Yale's Interdisciplinary Center for Bioethics. He was the chair of the Technology and Ethics Committee, the working group for many years. I've taken the reins over the last, I think, 2 years, 3 years or so from him. And I mentioned the organization because we have monthly meetings, and the meeting that's being held this month, in fact, is on that subject. It's on the subject of rendering psychological help, okay, using ChatGPT. One of our speakers, who's from the University of Arizona State, Katina Michael, had a chat with ChatGPT as if she were a patient. Right? And ChatGPT acted as if it was the psychotherapist. And this went on for pages, where at the end of the day, it was quite interesting how ChatGPT didn't disclaim the fact that it was just a machine, for example, and that anybody could be hoodwinked, not anybody, certainly she wasn't, we could be hoodwinked, okay, by engaging the machine in that manner. So we're having someone from Canada, someone from the UK, from Europe, someone from Australia, and two people from Australia to speak on that topic. So again, one of the things that's occurring here with respect to this sort of thing and the ethics and the laws that go behind it is that we're beginning to see sort of a world community all coming to the same conclusion with respect to what we need to guard against. I think that's kind of interesting in and of itself. Anybody in this room that would like to chime in, but listen in on that conversation, let me know and I can give you the Zoom information.
Okay, I got 2 more questions and we have 4 minutes.
All right.
So the first one is a question about the free AI tools and whether either of you know or have a sense of how the companies who are offering those tools are making money, kind of like what's in it for them and what's the risk to society with the free access to this.
Well, let me see if I understand the question. The question is someone is using one of these, the device to render.
I think it's just a general question of, do you know kind of how the mechanics of how those are being offered for free? Who's making money on the back end?
Oh, I got you.
I think there are big questions about how much money is actually being made, and we're lost on these tools at the moment. So I couldn't answer by giving an answer, but there is a lot of journalism about this that I think is probably worth taking a look at. The biggest issue is the cost of compute right now, which is tremendously high with respect to these technologies. So they're not technologies that can easily be offered for free from a real kind of cost perspective. And with the scarcity and kind of chip and computing power behind this, I think there are a lot of people looking into this question. But I wouldn't say I know the answer.
Okay. Last one I thought kind of a dramatic question, so the one to end on. And the question is, are we in a new form of arms race? And the questioner is specifically talking about the race to create and implement AI tools, and is also wondering about whether that has an impact and might be dampening regulatory efforts.
I'll say I think in some jurisdictions, yes. Like we have seen some jurisdictions, I think recently, like some jurisdictions in Southeast Asia come out and say, we're just not going to take a heavy-handed regulatory approach because we prefer to encourage adoption. I think Europe feels very strongly the other way, which is I think they believe it's a competitive advantage to regulate, and to regulate in a way that is aligned with what they see as responsible deployment, but also consistent with their other digital policies that are being kind of promulgated at the moment. But yeah, I think there is a tremendous amount of competitive pressure around AI, again, tied to a tremendous amount of competitive pressure around the chip industry. And I think it's hard to kind of disentangle the two as companies and as governments look towards their respective advantages in the next, in the next decade. So, that is to a certain extent filtering down as well. Like I said earlier, we're generally seeing companies very, very interested in adoption, but from a regulatory perspective, I do think we're going to see some jurisdictions that decide to not leverage their regulatory levers as a way of kind of encouraging companies to use them as relevant jurisdictions.
Yeah, and I want to mention, sometimes we speak about these things and we don't really envision what they mean economically or physically. What was mentioned by Wendell earlier, was he showed you a neural network, a little piece of it. NVIDIA, which is a computer company, manufactures chips that basically serve that purpose. And you may need 1,000 of these chips, right, in order to get one of these ChatGPTs to work. Each chip costs between $15,000 and $20,000. A company recently, and I forgot exactly which one it was, purchased 40,000 of these $15,000 chips. So you're talking about having to raise billions of dollars in order to get this system working. But there are huge companies now, NVIDIA being one of the big ones, like the IBM of today, that's heavily invested in ChatGPT, right? And they're not going to just let it go. So, and they're not going to want a lot of regulation on it. Like, how can you regulate it? Once it's in the chip, some of the algorithms are almost preset, they're established. And you just can't rearrange the chip. For software, it might be a slightly different story. But in these cases, it's hardwired.
Great. Thank you both. Thank you for your questions.
Probably not as good as what I did earlier this morning, but listening to the panelists confirmed that I retired at the right time, and that I'm grateful that I do not have to be learning all of this. In fact, my next chapter is what my son has just suggested to me this morning, sending an article, AI could be Apple's next chapter. So between Apple and NVIDIA, I got a lot of information today that I think might be useful. I also want to say that the judges that are here are not old and sclerotic, at least the ones that are here. I want to thank Stacy, Mayor, and Alana Underwood. This event would not happen without them. And just also, I'd like to thank our servers and those folks who have been helping us through the breakfast, the lunch, and of course, and I'm dating myself, the AV guy who's been walking around, and thank them for all they've done. The committee was great. Judge Armada asked me to do this last November, and I am so grateful because this has been an interesting and enjoyable task for me. It's also been very easy because of the members of our committee. Please look at your program so you can see who they are, who worked very hard to put this together. And of course, there's always some that work a little harder than others. And Allison Ware, Mark Dubois, Emily Giaquinto, I can't tell you how much time they spent on this, getting this ready, working with the various panelists. Of course, I want to thank all of you for being here. I think it reflects your interest in this very important and transformative topic. And there's no question that one of the speakers is absolutely right. The best people are the ones who come and learn about this.